Good afternoon, Your Honor. Before the court, again, Joseph Tashawn Simmons and 21 CF 817. We have reached an agreement with the time served agreement. I just need to have Mr. Simmons sign the top. May I approach?
Out, it's still wet.
Okay, just let
See that?
I'll just
So you do score out to prison, she's letting you.
right there.
Reading your right.
All right, Mr. Simmons,
Yes.
you raise your right hand.
Yes,
Do you
sir.
swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Joseph Simmons, 11/08/04.
Mr. Simmons, you're here in 21 CF 817. You can put your hand down. Charged with vehicle theft. I've been handed a plea and sentencing agreement that calls for adjudication of guilt, time served, and some costs. Is that what you want to do today?
Yes, sir.
Have you gone over this agreement with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did your attorney answer any questions that you may have had?
Yes, sir.
Are you satisfied with her advice and representation?
Yes, sir.
All right. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any mental health issues or concerns?
No, sir.
Have you been promised anything in return for this agreement or for pleading? Have you been forced, coerced, or pressured in any way into this?
No, sir.
All right. Do you understand that there won't be a trial of any kind, and you're giving up your trial rights, which are listed on page 2 of your agreement?
Yes, sir.
All right. Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
All right. And what is your plea?
No contest.
All right. I'm going to accept your no contest as to the vehicle theft in 21 CF 817 as freely, voluntarily, knowingly given, adjudicate you guilty. Credit for time served. $615 in court costs, $150 cost of defense. I'm going to give you 90 days to pay them. You can probably set up a payment plan as well, but otherwise they'll go to collections if you don't do that. You understand that?
Yes, sir.
All right. I'm going to need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. It's my understanding this is a downward departure based on uncoerced plea organ.
Yes, Your Honor.
All right. Thank you, sir. I don't think so. It wasn't a VOP.
He has a probation term out of Escambia that he'll be checking in for upon release. Yes, we're recalling Gregory Spears. I'm asking to continue this case to discuss further with my client what he
I
wants to
spoke with
do.
Ms. Flowers. I don't object to the continuance.
Okay. Looks like. Can I ask you, Mr. Spears, what's the correct spelling of your middle name?
D-U-A-N or D-W-A-N, either one.
Well,
I spell it D-W-A-N.
what does your birth certificate say? What does your birth certificate say?
W-A-N.
D-W-A-N. That is neither of the ones that I have here. All right, I'm just, because you're coming up in different spots on the docket because you almost,
I spelled it at my doctor's D-W-A-N. But my mom say no. She spelled it D-W-A-N.
okay. I'm just trying to make sure, especially when if ultimately you were to enter a plea or anything, I want to make sure that I've got the right name, date of birth. You hear, I guess you guys don't hear it, but I ask everyone their name and date of birth to be set on the record by you so that we know who you are. All right. Any concerns with the continuance, Mr. Spears? Okay. We're going to put it on April 30th at 9 o'clock. Looks like the most recent case is just from October. All right. We'll see you back on April 30th, Mr. Spears.
I'll try to get somewhere. All I have today, Your Honor.
All right. Thank you, Ms. Flowers.
Can I approach briefly with Ms. Flowers?
Yes.
Been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street.
Charles Russell, Public Defender's Office. Judges, Camden Barnum. Case number is 22 CF 3192. On this case, he's charged with second-degree murder with a weapon, life felony. At this time, we're going to ask for a continuance for complete depositions and trial preparation. As best I could tell, only 10 witnesses have been deposed, and the state recently filed a 20th amended discovery with some witnesses. Not sure if they're new, but I assume they are since they filed an amended discovery. But anyway, we have a bunch of depots too.
Your Honor, the state also filed an amended information for this case. He has not been arraigned yet. If we could do that now, it's still second-degree murder with a firearm charge.
When was that filed?
Filed January 27th, Your Honor.
it's the same charge?
Yes, Your Honor, just the firearm language was clarified. It's the same second-degree murder.
Okay. Have y'all seen the new information?
I don't remember seeing it, Judge, but we'll enter plea of not guilty, request trial by jury.
All right. What was your feeling on the continuance request, Ms. Glisson?
No objection, Your Honor.
All right. Are you fine with that, Mr. Barnum?
Yes, Your Honor.
Do you think you have to depose more people? I know it's new to you, Mr. Russell. Are you keeping the case at this point? Do you know?
That's something we need to discuss with you at the bench if we could, Judge.
Okay. All right, so we'll put it on April 30th for Mr. Barnum. See where it goes from there. Thank you, Mr. Barnum.
And Your Honor, I also have an amended information on Mr. Washington.
All right, what are we doing with Mr. Washington?
Judge, this
Well,
is-
first of all, I think that I was just told there's an amended information. Have y'all seen that?
Yes, Your Honor, that was actually filed back in December. He just hasn't been arraigned yet. This was Mr. Gibbs' case.
He has asked for a Nelson hearing. I'm guessing you're going to want to set that on a miscellaneous date. I've talked to him, I've explained to him that actually I would probably not be representing him on this. At this point, we're just not sure, but he still is not wanting the service.
All right, let me understand so I know how to resolve this, Mr. Washington. Who was your attorney up until recently?
Gibbs.
Okay, so is your concern with Mr. Gibbs, or is it somehow the public defender's office as a whole? Or was it Mr. Gibbs and now it's Mr. Williams? I just want to make sure I understand so I know what we're trying to do with it.
No, I had conflict with him. Well, I filed for a Nelson hearing with him.
Yeah, and I think the last time we were here, that he wasn't here, and frankly, I wasn't privy as to whether or not he was going to be back. And it sounds like, from what I'm being told, is he's not going to be in this division any longer, so therefore he wouldn't be your lawyer. So I'm not sure who the public defender's office is going to assign it to now that Mr. Gibbs won't be your lawyer anymore, but do you want to have a chance to speak with that person first, or do you want me to look into it? Yes?
Yes.
Okay. So And that's why I didn't set it for a Nelson hearing, because I wanted to make sure that you were able to say, I don't want that guy anymore, but he won't be your lawyer anyway, so it's kind of.
But if I'm having conflict with him and he's in that office, doesn't that give me conflict with the office, or?
I don't
How does that
necessarily
work?
think so, because it's not like, well, if we have a hearing, we could potentially do that, but if you want me to try and have a hearing where I conflict the entire public defender's
Yes,
office,
sir.
I can do
No.
that, and then I can appoint you to the regional office of conflict
sir.
counsel potentially, but, is that what you want to do?
Yes, sir.
All right, then we'll have to set it for a hearing, and you're gonna have to show me that they've done something
Yes, sir.
wrong, and, not handling your case properly before I'll do that. Okay.
Judge, if I can inquire, are you okay with me representing you for the purposes of your arraignment today on the amended information?
Yes, sir.
Okay.
All right, go ahead, Mr. Williams.
Judge, I'll enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, demand trial by jury.
So not guilty will be entered as to the amended information from December. Is Mr. Gibbs going to be available to appear at a Nelson hearing anytime soon?
Will make up in court.
That's what I'm trying to figure out calendar-wise where I can put this. I'd like to do it sooner if I can, just because this is a pretty old case, and if he's starting over with not only a new lawyer, but a whole new office.
Tell me what date, Judge, I'll see what I can do.
Okay. What do we have on the morning of the 6th? Like 1, right?
There's a possibility that someone else will have to handle my stuff on the 6th, simply because I've got surgery on the 5th. It's relatively minor outpatient surgery, but.
Well, that's why it's kind of a confusing thing that you'd be representing him at a Nelson hearing where I'm trying to find out whether or not one of your coworkers didn't do anything properly, so.
And I don't know that that's even an issue for me to be here. I'm just making sure nobody's
Why don't we put,
surprised.
Ms. Glisson, can you be here for March 6th?
I should be able, well, I do have,
Well, I was thinking morning, because I think we only special set 1 in the morning
And-
that day.
if I can't, Your Honor, I can have someone covered. It's my understanding Nelson hearing, we don't
You don't have
do
a
much,
whole lot
right?
in there, so I'm gonna say 9:30. I think I previously said 9 for 1 o'clock, but it looks like I have an RPO that goes to 9. It goes at 9. I have an 8:30, 8:45, and 9 o'clock. So I'll just say 9:30 to make sure that you guys aren't sitting around watching RPOs. Or
Yes,
waiting out in the hallway while we do RPOs.
And you said March 6th, Judge.
March 6th, so that'll be a week from tomorrow, Thursday, March 6th at 9:30 for the Nelson inquiry.
Yes, sir.
Any other questions, Mr. Washington?
No, sir.
Okay. I know it's kind of confusing. I'm trying to figure it out myself just because I've only been involved in your case for a very short time, but we'll get it figured out that day.
Thank you.
We'll put it on the April 30th pretrial at this point too, but we'll talk about it on next Thursday. Thank you. Anna.
Jacob Price.
All right. I'm just trying to figure out where we're at. Is this under you, Ms.?
Yes, Your Honor.
All right, go ahead with Price.
That would be Jacob Price, Your Honor, 19 CF 3106. We have just completed 2 rounds of depositions. We have another one scheduled for Friday, and we anticipate having to do at least 1 more of makeup depositions. We are requesting the next court date.
No objection, Your Honor.
Okay. And he just got back to us recently,
Yes,
right?
sir.
Okay.
Correct.
All right, April 30th, we'll see you back on that day, Mr. Price. And they'll finish up some depositions. We'll talk about what's going to happen after that.
And I'll be out to update you on
Okay.
everything.
Thank you.
Okay?
Is that you?
It is and it isn't, Your Honor.
There was a few motions to withdraw you sent, but it didn't say what the conflict was, which you normally do. I just wanted to make sure if that's something we had to talk about or if.
May we approach, Your Honor?
Sure.
Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right, this is Corey Valley, correct, sir?
That's correct, Your Honor.
Yes? Okay. All right, 23 CF 1996. Did y'all get depositions done on February 11th, or was a?
No, Your Honor.
Okay, and I see that the Public Defender's Office has had to file a motion to withdraw. So what I'm going to have to do, Mr. Valley, is allow them to withdraw and appoint you the Regional Office of Conflict Counsel to represent you. Do you understand that? Okay. So I will go ahead and do so at this time. And what I can do is put you on the April 30th docket, and then RCC lawyer will come out and talk to you in the meantime. I'm not sure who that's going to be. I'm not sure if Ms. Flowers handles every case in this division or if there's other ones that she doesn't. So it'll probably be Ms. Flowers. All right. Any questions, Mr. Valley?
No, Your Honor.
All right. Thank you, sir. We'll see you back on April 30th. All right. And I'm signing that order right now.
Mr. Norris, your dad was out here earlier.
Sure.
Your dad was here earlier. Yeah. Judge, we had the stand your ground hearing. We're in the process of providing the written arguments. Let's leave it on for 3/3. I believe that's going to be the date for my written response. Although I'd spoken with the state, we may want to meet with you, sort of a case management thing in chambers, just to discuss where we're going to proceed and whether or not, what we're looking at in terms of times.
What do you mean as far as times?
Well, as far as when the trial's actually going to take place.
Is either side asking for it to be continued for any reason?
Well,
I know it used to be, we all met in chambers, back when I was a lawyer too, and we would talk about things, and I think that's kind of frowned upon by doing things off the record.
Well, I think we're looking for some guidance from the court right now. My argument is due on Monday, and then the state has 5 business days from then to do their final argument. And that's going to put us depending on when that fifth day comes up, either the following Monday, jury selection, because it's business days, or
I mean, can y'all see if you can push it a little bit and get them done a little sooner? I mean, Mr. Norris, if someone didn't explain it to you, one of the slowdowns here was getting that transcript ready, and the courthouse was closed for the better part of a week because of a snowstorm. And so just the official court reporter's office was a little bit behind getting to the transcript, is my understanding, which meant that the state filed theirs a little bit late, which I told, they had to wait for actually get the transcript in hand before they could do it. And that kind of put all those timelines that I put into effect back on January 15th, if I'm not mistaken, put it behind by a good week or so. I mean, I'll make a decision as quickly as I can once I get to read everything. But in fact, I started reading the state's first brief, and then I realized, what's the point of reading it now? I'll wait till they're all in at once so I can read them all at once instead of trying to rely on my memory from the last time. But I just want to make sure you understand what the delay was. But Mr. Williams, and I know Ms. Glisson you're covering, but it's Ms. Sandler's case. I mean, can y'all potentially get these things a little bit sooner to me? I mean,
Judge, we'll
I
do
know
the
you're
best we
busy,
can.
but
We just want to make sure the court has enough time.
I'll convey that to Ms. Sandler. Ms. Sandler was requesting.
okay, because what even my intent at this point was, if I don't have anything by the end of the week, I'm still probably going to, this weekend, read the transcript so I have it fresh in my mind. I mean, it's a day and a half. I think it was about 500 pages, just so it's fresh. So when I get the arguments, I can read through them quickly and make a decision one way or the other. But, I can't make a decision until I hear everybody's part of it.
Yes, sir. We're just trying not to rush the court.
If this case is going to go to trial, I'd like for it to go to trial this cycle, if it's at all possible.
Yes, sir.
I've been it's been in my mind this was going to go, if, depending on what I determine on the stand your ground, it would be going this time. And frankly, it's in my head every time I look at how many trials we've got set, and if I'm going to have to get people to cover some of these other trials so that I can do this one, because I think this is the kind of case that the actual divisional judge has to handle. So
Yes, sir. Well, and the court also heard the stand your ground. So I
think that's why it was all saved for me in the first place. All right, so.
The 3-3 judge.
We'll come on 3-3. I mean, do y'all want to talk about, you're going to send out subpoenas for this time around, and does 1 week work better for y'all if it's going to go?
Judge, I hate to get too deep in it since she's not here, but I'm thinking the second week would be the better week, simply because of, again, that gives the court, the court would not be even getting the final brief unless we did expedite it until the morning of jury selection, if we did it the first week. If we did it the second week, the court would at least have a week to review everything and make a wise and considered decision.
I was assuming we'd do it the second week anyway. I was trying to push anything I could to that second week just because I was hoping to go to the Judicial College the week before. It looks like that's not going to happen at this point. So I've always kind of assumed this one would be the week of March 17th.
Yes, sir.
But we'll talk about it more on Monday. But again, as soon as I get everything, I'll read it and make as quick of a decision and written opinion as I can.
Yes, sir.
Yes. Thank you, Ms. Glisson.
I'll come out and see you. We've got an issue to talk about in terms of how we handle it if.
Charles Russell, Public Defender's Office. Mr. Brown is before the court on 3 cases, Judge. 22 CF 1823, which is a VOP, 22 CF 1420, which is a VOP, and 24 CF 2757. The 2757 case is a first time up. VOPs are based on the new law, and so we're asking for a continuance of all 3 cases.
Objections, State?
No objection, Your Honor.
Your Honor, may I speak?
Yes, sir.
Yes, Your Honor.
I always ask them first, then I always get back to you.
Oh, okay.
The-
Oh, my
the
bad.
Ping pong in my head that I play. Go ahead.
All right. I just want to say, since I was violated before I got arrested. That was
Okay.
the whole reason of me
Let
being
me stop you,
arrested.
Mr. Brown. I just want to make sure you understand that everything that happens in this room is recorded.
Yes, sir.
And so if you say anything that could be detrimental to your case, what you say could be used against you. That's not in a way to discourage or, make you feel threatened
understand,
about
I
saying
understand.
anything, just so you know. So don't say anything that could be detrimental to your case, okay?
Okay.
Go ahead.
Well, I was,
If you'd
you
like
say
to.
I got 2 violations. I only had 1. I was only on 1 probation.
Well, you've got 2 different cases that are in VOP status. There's 22 CF 1823, and there's 22 CF 1420, are your 2 VOP cases.
Okay.
Then you've got a new law violation, 24 CF 2757, which is probably the reason why you've been violated. But even if you're in violation status and something new happens, they just do an amended violation report, and that ends up on that as well.
Okay. And also, my lawyer, I had sent him several letters. My family had reached out several times for him to come see me.
Was that Mr. Gibbs?
Mr. Russell here.
Mr. Russell?
Yes, for score sheets, the FDLE reports, and everything that try to help me to help him get a defense in my case.
In the new case?
Yes.
Okay.
As well as the VOP. Because the last time I seen him, he told me he had just got my file and he haven't looked at anything, and that he would get back with me. So I wrote him and asked him what to look into and what we can try to do, and I can try to help him. But I never heard anything back from him or anything, and I just want the court to know that.
Okay, well, I understand it, but let me just take a quick look at this. This is your first time here for a pretrial conference, right?
Yes, I came back in December, like December the 9th.
It was right before I took over, yes, sir.
Yes, sir.
I started, my first court date was December 30th in this district.
Yes, I think we had gun terror. Yes, sir.
12/26 was his felony plea day, Judge.
Yes, that's what I thought. So that was your plea day, and so let me see here. I'm trying to find. An amended information was filed on January 13th. I don't even. As discovery was filed on January 10th. Has the state provided everything they have as far as discovery?
Yes, Your Honor. Other than the initial discovery, we have done 1 amended discovery, but that was an offer and a score sheet for all cases.
Okay, so they've now provided that. I would be surprised if y'all had an FDLE report to hand over at this point.
I believe the amended information was based on an FDLE that came back, I think. Let me look here.
Oh, it looks like the amended information consolidated the misdemeanor DUI into this case.
That's right.
Correct, Judge.
Okay. That was the reason for the amended information. We don't have FDLE back yet.
So, Mr. Brown, they probably haven't even received an FDLE report yet. Certainly, the state, I don't think even has it, let alone has turned that over to Mr. Russell yet. Unfortunately, that can take a couple of months or more.
Okay.
That's correct.
So that's why they're asking for more time. If you've got concern about that, and they haven't turned over the information, we can, you can talk to Mr. Russell and you can decide to do something other than continue the case if you'd like.
Yes, sir.
What would you like to do?
I guess I'm gonna just wait till he come see me and see what's going on from there. Then at the next court date, I guess if I ain't satisfied, I'll say something or I'll file a motion to dismiss attorney or.
you can certainly do that. It's called a Nelson inquiry, and I can ask you some questions about that. But, Mr. Russell, any chance this is going to change again?
Yes, sir. But I can make it a point to go out and see Mr. Brown this week. Get with him about the discovery and the stuff that he sent us letters about, and discussions with his family, at least get that taken care of.
One of the things I will tell you, and Mr. Brown, you don't know me, but I was a criminal defense lawyer for most of my career before I took the bench. And one of the things is attorneys aren't really supposed to talk to families until you give them approval to do so. So he's got to make sure to have something from you before you can
Well, I
talk
wrote
to
him a letter.
I
giving him
understand.
permission,
So, but he can't do it until he gets that letter, and they deal with a lot of cases because you have a confidential, privileged relationship
Right,
with
right.
your attorney.
Understood.
And he may need to talk to you about whether or not there's things he should be telling even your family.
Yes, sir.
I used to kick families out of my office all the time while I talked to my client. And so I want to make sure you understand that's how sometimes it has to work. So he'll come and talk to you this week, like he said, and then we'll come back on April 30th. Again, if something comes up, you need to come in front of me sooner than that. Mr. Russell can get something set sooner than that.
All right, thank you.
All right, any other questions, Mr.
No,
Brown?
sir.
All right, thank you, sir.
Charles Russell Public Defender's Office. Judge, Mr. Carnes has two cases on the docket, 22 CF 1268, which is a VOP, and 24 CF 2782, which is a new law violation. This is a first time up on the new law violation. The VOP is based in part on that. So at this time, we're going to ask for a continuance of both cases.
No probation, no probation.
Mr. Carnes, any concerns with that? Mr. Carnes?
No, sir.
April 30th.
The Joseph Carroll.
Charles Russell Public Defender's Office, Judge, this is Joseph Carroll. Case number is 24 CF 2383. Mr. Carroll scores almost 98 months in Department of Corrections. My review of the file shows that no depositions have been done yet. So at this time, we're going to ask for a continuance of the case to complete depositions and trial preparation.
Please be set for docket day. There's
24 CF 2383.
And Judge, Ms. Barrettman did tell me that before she left. I forgot about that. I'm aware of what she's talking about.
All right, so we want to set it on for Monday to discuss it?
Yes, sir.
Okay. March 3rd at 9 o'clock, Mr. Carroll, we'll see you back on that day. This is a pretty new case, so I'm not surprised depositions aren't done. All right, we'll see you back on the 3rd, sir.
Sir, I'm waiting on Riggs and Tatum. I've been here to see Wheeler. Miss Wheeler?
Wait, who's this?
Your Honor, this is Amanda Wheeler.
And Your Honor, just for the court's knowledge, I believe I'm listed on one of the cases, but Ms. Rivers is going to be handling that.
Okay.
That's correct, Your Honor. So this is Amanda Wheeler before the court on 23 CF 224. We've reached an agreement in this matter, if I may approach.
You good? I think I got some cough drops back here if you need some.
Thank you. was an add-on, Your Honor.
Okay, that's why I'm not finding that. Thank you. All right, Ms. Wheeler, can you raise your right hand?
Yes,
Do you
sir.
swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your name and date of birth, please?
Amanda Gail Wheeler, 12/10/1983, sir.
Ms. Wheeler, you're here in 2023 CF 224 for a violation of probation. I've got a plea and sentencing agreement that calls for you to do 6 months of community control followed by 2 years of probation with some other conditions, right?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right. Have you gone over this agreement with Ms. Rivers?
Yes, sir, I have.
Okay. And did you understand it all?
Yes, sir.
Is this the only case that she's here for? Okay, just because of what Mr. Maddox said, I want to make sure there wasn't two that I was missing. All right. Did you understand the agreement?
Yes, sir, I did.
Did she answer any questions for you if you had any?
Yes, she did.
Did you sign the agreement?
Yes, sir, I did.
All right. And are you satisfied with Ms. Rivers' representation?
Yes, sir, I am.
All right. And are you currently under the influence of any alcohol, drugs, controlled substances?
No, sir.
Any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promised you anything in return for this plea?
No, sir.
Do you understand that by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove that you violated your probation
Yes,
in
sir.
the ways they've alleged?
Yes, sir.
Okay. Do you understand you're waiving any potential defenses that you may have?
Yes, sir.
Okay. All right. And what is your plea? Are you admitting your violation of probation or denying it?
I'm admitting.
Okay. I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to continue to adjudicate you guilty if you weren't. Well, I'm not sure if you were adjudicated, but it will be adjudication now. You understand that would make you a convicted felon
Yes,
if
sir.
you weren't before. Okay. 6 months community control followed by 2 years probation. Special conditions is to testify truthfully. $100 cost of prosecution, $100 PD fee, $50 application fee, and I'm going to waive cost of supervision for you.
Yes, sir.
Any questions about
No, sir.
that? All right, you're going back on community control and probation, so I need you to go talk to them. Then you'll be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Okay, thank you, sir.
This
No,
is,
no,
hold
just
on.
for this, if I may, just for the sake of clarity, testify truthfully in case number 23 CF 111.
Okay. Y'all want me to usually announce it like that?
She's a witness in the case.
I understand.
Yeah.
I'm fully aware. Christian Alex Douglas.
Okay.
We can say his name, it's fine.
Well, I know you're aware.
Okay. Do you want me to go there?
Otherwise, you wouldn't be a witness.
Okay.
All right, yes, go talk to probation, then you'll be fingerprinted.
Okay, thank you.
This appears to be a downward departure based on uncoerced plea bargain, is that right?
Yes, Your Honor, that
I
is.
think she scored 1/10 of a point over, something like that. Oh, no, there's some more on the back.
Yeah.
Okay, so it's 50.1 for 16.575. It's a,
Your Honor, are we revoking the old probation? Revoking?
revoke old probation, this will be new community control, 6 months,
Gotcha. Thank you, Your Honor.
followed by 2 years probation.
Thank you.
6, 2.
That's mine, Judge.
Just a second.
Charles Russell Public Defender's Office, this is Ms. Beckham. Case number is 24 CF 2185. On Ms. Beckham's case, Judge, we had a competency hearing back on February 6th, and there were some questions about that report at that time from Dr. McDonald. She has filed an amended report. I provided a copy to the state, and I provided a copy to the court earlier. I would like to file this report as Defense Exhibit 1 and ask that the court order it to be sealed. Dr. McDonald basically concluded she's incompetent and she should go to the state hospital. If I may approach?
Yes, sir. Well, I've got mine already, so if you just want to give that one to the clerk, this is to be held under seal. Do you need anything else? I don't know, do they have to do it?
Which state hospital are they talking about?
Okay.
I don't want to go to Chattahoochee. That's
Things run a lot differently on sealing things that get filed like that in civil or family, so I just want to make sure that we're complying with the clerk's rules. All right. We just have the one report from Ms. Beckham, is that right?
I can give you the old report if you want to, but this is the one that, it basically tracks the other report except at the end, the recommendation.
Is that filed in a different case?
No, sir. I had given it to you at the last hearing, but then when there were questions about the recommendations, the court suggested that I get an amended report, and then I talked to Dr. McDonald, and
There's
this is...
concerns about what the ultimate recommendation for what we should do post-competency determination. Or is this your case?
It is.
Do you have any objection to me making a determination based off this report?
No, the state would stipulate to doing so, Judge.
Did I actually determine that she was incompetent last time?
No, sir.
Okay.
We're going to wait and see what the amended report says.
I just wanted to make sure where we're at so I don't have duplicate orders or anything like that.
I had a question.
All right, so based on the stipulation and my review of the report from Dr. McDonald, and this is the amended one that was dated December 28th of 24. That Ms. Beckham is not competent to proceed, and that based on the recommendations of Dr. McDonald, which is why we got the new report, that the appropriate treatment would be at the Florida State Hospital under the care of the Florida Department of Children and Families. I'll order that at this time.
And I'll send you a written order, Judge. Did you want to set a control date 3-6 months out for review?
I think that would be a good idea.
Did they have any kids?
Trying to remember what she said about time. I think she said, it's estimated, it says 6 months.
And if the state hospital determines she's competent before then, they'll send us a report and we move the report up. I mean, the hearing up.
All right, do you want a miscellaneous date, Mr. Russell?
Yes, sir.
Maybe August 7th, which is a little less than 6 months, or I can do September 25th, which would be more than 6 months.
Sure.
Do August 7th,
9 a.m., Judge?
9 a.m.
Aware of Dykes.
Your Honor, I would ask that you not force the issue.
Cover that case now, then. All right. Go ahead and announce it, Ms. Rivers.
Your Honor, that would be 21 CF 1909. He also has 21 CF 1811. If we may approach, Your Honor.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
6.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
All right, so as far as Brandon Dykes, we'll bring him back. I didn't announce it already. It's 21 CF 1811, 21 CF 1909. We'll bring him on Monday to discuss the issues with him. And I'm sure he'll want to come talk to us at that time.
Charles Russell, Public Defender's Office. Judge, Mr. Arnett has case number 24 CF 977 and 24 CF 1243. The state recently provided me a new score sheet where Mr. Arnett scores out to 30.75 months Department of Corrections. No depositions have been taken, so at this time we're going to ask for a continuance to complete depositions and trial preparation.
No objection, Your Honor.
All right, Mr. Arnett, anything you want to tell me? No. All right. April 30th to do depositions.
Judge, this is Jeremy Altman. Case number is 24 CF 1777, if I might have a moment.
Talk to me. You're good with it. You're ready to sign.
Yes, sir. That's probation and everything.
Judge, I have a plea agreement and score sheet if I may approach.
Yes, sir. Mr. Ottman, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Jeremy Peyton Altman, 06/16/2000.
All right, Mr. Ottman, you're here in 24 CF 1777. You're currently charged with battery upon a person over the age of 65, which is a third-degree felony, and felony battery, which is also a third-degree felony, and they're both punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that calls for you to be to plea to count 2, the felony battery, and get 36 months probation and some conditions. You're aware of those?
Yes, sir.
All right, is that what you want to do today?
Yes, sir.
Did you go over this plea and sentencing agreement with your attorney, Mr. Russell?
Yes, sir.
And did you understand the plea agreement?
100%, yes, sir.
All right, did you sign it?
Yes, sir.
Yeah, and if you had any questions, did Mr. Russell answer those questions?
Yes, sir, he did.
And are you satisfied with his advice and representation?
Yes, sir.
All right. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues or concerns? All right. Has anyone forced, pressured, or threatened you in any way?
No, sir.
All right. Has anyone promised you anything in return for you entering a plea? Do you understand by entering a plea to the felony battery, there won't be a trial of any kind, and you'll be waiving your trial rights, which are on page 2 of that agreement you signed?
Yes, sir.
All right. Do you have any questions about those?
No, sir.
Do you understand you'll be waiving any potential defenses that you may have? All right. And what is your plea to count 2, the felony battery?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. I'm going to withhold adjudication as to count 2, felony battery, as to count 1, state.
I'm sorry, the state dismisses count 1.
Okay. And this is a guideline sentence, correct?
Yes, sir.
Okay. All right, withhold adjudication on count 2, 36 months state probation, waive cost of your supervision due to the fact that you're represented by Public Defender's Office and are indigent. You're to complete a substance abuse evaluation and any recommended treatment. You're subject to random urinalysis for the detection of any sort of drugs or controlled substances.
That's fine, yes, sir.
That you're not allowed to have. Obviously, if you were to be positive for one of those, that you would be violated. You understand that?
Yes, sir.
Okay. You understand that you can do 5 years prison if you get violated?
Yes, sir.
All right. You're also complete batterers intervention program. That's a 26-week program. So make sure you get started with that.
Yes, sir.
Am I right? Okay.
Got to.
All right. Also, no contact with, I'm going to need help with this one, Mr. Russell.
Carrie Taylor?
Carrie Taylor,
Yes,
okay. So no contact with Carrie Taylor. Even if she asks you to have contact, you're to have no
Just
contact
nothing.
with her, subject to change to the court's order. Court costs for felony battery, $867 in court costs.
Yes, sir. That's fine.
Yeah, and there's a battery surcharge. So, and then you've got a $150 PD fee. I've already waived cost of supervision. Anything that I've missed? All right. Mr. Ottman, I'm going to need you to go talk to probation. I'm going to need your fingerprints. I know it's a withhold, but it is an enhanceable battery offense.
Sure.
And also, you've got 30 days to appeal the judgment and sentence of this court.
Your Honor, in the event they can't, the treatment provider wants to do one of these before the other, is there any treatment program that the court would recognize that he needs to complete the batterer's intervention before the substance abuse or vice versa?
You know, I always used to say this in dependency court, that we want you to be sober before you start learning how to do the other things. So it's always better to do the substance abuse stuff first before batterer's intervention. I think they're both usually needed equally, but if you're using.
Judge, this is Jake Bell. Case numbers are 24 CF 2560, 24 CF 2907. Both first time up, so at this time we're going to ask for continuance on both cases.
Objection? All right, we'll have you come back on April 30th, Mr. Bell. Someone come out and talk to you some more, but they're just trying to get through the discovery process.
Thank you.
Judge, this is Dwayne Bonnick. Case number is 24 CF 2696. Mr. Bonnick's case is a first time up too, so at this time we're going to ask for a continuance to the next pretrial conference.
No objection.
All right, Mr. Bonnick, we'll see you back on April 30th. Someone come out and talk to you about it. They're just trying to go through the discovery process. Harrison? All right, let's not call him now, because now that I know that he's here, I've got a note. It's sitting on my desk. I saw it during my 20-minute lunch. And it has all the information from your last court date, Mr. Harrison. I went back and watched it because I wanted to make sure I knew what happened, because I don't think I was there. It was a different judge. So I wrote it all down, but I didn't bring it with me because I didn't expect you to be here today.
Booker.
No, I'll take a recess.
Judge, this is Ricky Booker. Case numbers are 24 CF 305, 24 CF 354. Mr. Booker scores out to 246 months Department of Corrections if the score sheet is correct. So at this time, we're going to ask for a continuance to complete depositions. And for the court and the defendant's information, we've also set a bond reduction hearing for March 27th. I'm going to give him copies of the notice of hearings.
This case is a year old.
Yes, sir. There were some depots that were set for February 25th, Judge, based on...
Yesterday?
Maybe
The
February
18th.
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 February 18th, okay.
Because of the situation with Mr. Gibbs and not knowing when he would come back and et cetera, they were canceled.
Mr. Booker, anything that you'd like to tell me about the situation? How long have you been in jail?
Over a year.
When's the last time you saw Mr. Gibbs?
Almost a year.
It's getting to the point I don't think I have a choice as to what I'm going to have to do next with Mr. Gibbs. I'm going to continue the case so you can have a lawyer actually look into your case. And we'll put you on April 30th. Have you come back that day with your new lawyer. Do you know who that's going to be assigned to at this point, Mr. Russell?
Based on the charges, Judge, I think it's going to be Ms. Rivers. Sorry, Mr. Williams. First half of the alphabet is going to be Mr. Williams.
So he's going to have the first part and the end part?
No. Can I approach, Judge?
Yeah, go ahead.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
So, Mr. Booker, we'll see you back on April 30th. It looks like you're going to end up with Mr. Williams as your attorney, so he'll come out and talk to you at some point, and then we'll see how quickly we can get your deposition set up is what they were talking about doing for you, and kind of fast-track your case a little bit from here.
Okay.
All right. Thank you, sir.
Thank you. Judge, this is Merton Braley. Case number is 24 CF 1659. Current offer on the table is 24 months Department of Corrections. Best I can tell, no depositions have been taken in this case, so at this time we're going to ask for continuance to complete depositions and trial preparation.
State. Mr. Braley, am I saying that right? Anything else you want to tell me? So this is...
I just hope for a sooner court date, you know.
What's the offer from Mr. Braley? Y'all know.
I'll pull it up.
All right, Mr. Braley, we'll see you back on April 30th with your new counsel.
Sir.
Charles Russell, Public Defender's Office, Judge. This is Chad Brown. Case number is 23 CF 2214. The offer that I saw in the file was 25 years in the Department of Corrections. Depositions were taken back in June of last year, but only 5 of the 10 witnesses that were set actually were deposed. This time we're going to ask for continuance to complete the depositions and prep for trial.
Over state's objection, Your Honor. The state is ready for trial.
Mr. Brown, anything that you want to tell me?
Yes, sir. Just on the record, he's new on my case. So I caught this in 21. I requested a speedy trial. The state provided for me Timothy Gibbs. He ignored my request, denying my rights. So I filed it myself, along with 2 Nelson hearings, and the state denied appointing me a new attorney.
Well, the state, hold on. Let me just correct you on that.
Yes,
Mr.
yes, sir.
Brown.
Yes, sir.
The state doesn't appoint you lawyers.
Oh, yes, sir.
The court does that. I mean,
The court-
this is probably the first time I've been on your case. I don't remember seeing you last time. Maybe you were here last time.
Yes, sir.
But no, that's the court's job.
Okay.
So my understanding is you're not going to have Mr. Gibbs anymore.
Yes, sir.
So will this be Mr. Williams then?
Yes, Your Honor.
Also, Mr. Williams is going to be representing. He's standing right behind you.
Thank you.
So he'll come and see you and talk to you about the case. It won't be Mr. Gibbs anymore.
Okay.
But go ahead and say whatever you want. I just wanted to make sure
Yes,
you're
sir.
under the correct impression of how these things work.
Yes, sir. Thank you.
Go ahead, Mr. Brown.
Okay. So after being denied my right to a speedy trial and the Nelson hearings, I never got a new attorney until now. 3.5 years later, I'm still charged with armed home invasion on a house I lived in for 10 years. I have a CDL driver's license with that address on my license, a business license with that house as my home office. And
Isn't this a 2023 case?
no, sir, I was booked in here
It is,
in
Your Honor, but the
2023.
incident is from 2021. It took a while for him to be arrested, and that's why. So the offense is 2021.
Okay, well, our case didn't start till 23.
Yes.
Yes, sir. I was actually arrested in 21, but it was in another state.
Well, let's make sure we're clear about it. Why didn't you get here until 23?
Because I can't really. I've already.
Were you in jail in another
yes,
state?
sir. Yes, sir. It was.
So your concerns about 21 and 22 and most of 23 are because you were incarcerated somewhere else
Yes,
or something
sir.
else, right?
Yes, sir.
Okay.
Anyways, the house that I supposedly, allegedly invaded.
Judge, could I have a moment?
Mr. Brown?
Oh, I mean, that's a false charge. Yeah. Anyways, I just want to put it out there. I am afraid of my life. This thing is so blowed out of the water. 25 years, I have children. It was, I can't go into details. I don't want to incriminate myself, and hopefully I can get some decent representation. I've been pleading for the longest now.
I understand.
Yes, sir. And God bless the courts. And
I can't do anything
and everything.
about the past, but what I can do is make sure you've got representation who will come out and talk to you and work
Yes,
on your case and handle depositions.
Well, the thing is about the speedy trial, I keep bringing it up to everybody, and it keeps getting deflected. Like, because my attorney didn't file it, I filed it. It still got ignored. I don't get the rights like a normal person. That's my only thing. You know what I mean?
I'm not giving you legal advice, Mr. Brown. What I'm doing is explaining to you how these things work. When someone's represented by counsel, if they file something other than what we consider something called a Nelson inquiry,
Mhm.
which is saying my lawyer's not doing his job,
Yes.
or her job, unless your attorney adopts your pro se motion that you filed,
Yes.
it's what we call it. It's a nullity.
Okay.
So it's like it wasn't done. But what you're going to do is talk to Mr. Williams, who it looks like he's going to be representing you going forward.
Yes, sir.
Explain what you want to him. When a case gets continued and it's attributable to you or your counsel, you kind of waive that right to speedy trial. However, it can be started back up.
Yes,
but
sir.
I'm not going to go through all those dynamics with
Well,
you. I'm
thank
sure
you for
Mr.
letting me know
Williams can
that.
explain that to you. But I can only deal with what's in front of me.
Yes, sir.
And if
I
something
understand.
hasn't been done, the only thing we can do to fix it is to do something new.
Yes, sir, I understand. Well, also, my other thing is there any way I can get an attorney from a different office? It's kind of like that fool, you know what I mean? Shame on me the first time. I'm just afraid that you know what I mean? It's going to be the same
Well,
repeat.
Here's what would happen. If you want a Nelson hearing, say, I don't want any of these guys. The only thing I could do, if I find that's the right thing to do, is appoint you to the Regional Office of Conflict Counsel.
Okay.
Okay, so who's just, is a different, kind of a secondary agency that is like a second public defender's office.
Okay.
And they would assign you an attorney. Obviously, you're free and have the right to hire anybody you want to hire.
Yeah.
As long as they're licensed in the state of Florida. But you can't, if you're asking for one to be appointed, you can't handpick them.
Yes, sir, I understand that.
But just trying to give you that idea. Again, Mr. Williams will explain these things to you. I'm not trying to tell you what you should do, just kind of giving you some information as to how it works.
Yes, sir, Your Honor. I have nothing else to say. Thank you
Well,
so
again,
much for the time.
You are welcome and have the right to tell me anything you want to. We just don't want you to talk about your case and do something
understand.
bad for you.
Yes.
But you can tell me what you'd like to tell me. I appreciate the fact that you did that. But we'll have you come back on April 30th with your new counsel, and we'll see where things have gone in the next couple of months.
All right. Yes, sir. Thank you.
All right. Thank you, Mr. Brown.
Your Honor, if I may ask, the deposition be set before the 30th?
Yes. I think if we're only talking about 5 witnesses, that shouldn't be too difficult.
The main witnesses were already deposed. So,
deposed.
yeah, the victim was deposed, so.
Do you have transcripts from that or know where they might?
The recording was with Mr. Gibbs. They would have to provide it to me. I don't have the recording. You do?
I'm not 100%.
I'm not sure, Your Honor. I don't know.
If not, we'll get them transcribed.
Okay. We just want to make sure everyone's got the recordings and/or transcripts, Mr. Brown.
Is there any way I can get a discovery?
We'll talk to you about that.
Thanks, sir.
Colton Riggs.
Your Honor, this is Colton Riggs before the court. He has 3 cases. That would be 24 CF 499, 24 CF 2212, 24 CF 2231. We're in negotiations with the state. We're trying to work out something, and hopefully we can get this handled before next cycle has come around.
Mr. Rose, I was under the impression that we were going to resolve it prior to that with inpatient treatment or.
And if I may. With the credit he's gotten already since he's been in this time?
I would have to defer to Ms. Claw because if the program requires him to be inside for the whole 1129, can we send him, bring it back on Monday and I can discuss with Ms. Claw? Okay.
Hey, Your Honor, if we could put this on Monday.
We should resolve it, hopefully.
Think it'll be resolved that day?
We're trying.
That's fine. I mean, if it isn't, it isn't. I mean, it's
Yeah.
not a terribly old case, but.
No, I know. I just wanted to resolve it.
Monday, March 3rd, we'll see you back, Mr. Riggs.
Sir, thank you.
I'm assuming Ms. Rivers is going to talk to you before then, but.
Thank you.
Your Honor, this is Tony Tatum before the court on 24 CF 2304. The state has conveyed an offer to me, and I'm going to convey it to him at this time, Your Honor.
That's fine.
Set it for trial? All right. Your Honor, yeah, he's probably going to take just a minute.
Mr. Tatum. This is 24 CF 2304. Did y'all want to put the plea offer on the record?
Yes, I was going to ask the. So, Your Honor, if the court remembers, this case was set for a VOP evidentiary, and the court has sentenced Mr. Tatum already to DOC time. So, for the purposes of the new law, I was offering a misdemeanor plea for time served.
Okay.
And he's rejecting that.
Okay. Mr. Tatum, you understand if you go to trial, this is not any indication of what I would do. I just want to make sure you understand what the maximum potential penalties are. If you were to go to trial on the obstruction and the felony battery, they're both third-degree felonies, correct?
Yes.
So he's looking at a maximum of 10 years in state prison on that, if they
Yes,
remain
sir.
consecutive. Do you understand that, Mr. Tatum?
Yes, sir.
Again, I don't know anything about the facts of this particular case, although were these the facts that were part of the...
Yes, they are.
Okay.
Yeah.
So obviously, we had the VOP already, where I found that you'd violated your probation, but a jury would decide the facts as to whether or not you've committed these crimes. You understand that?
Yes, sir.
All right. Any questions?
No, sir.
Okay, then we'll put you down for, do you want to bring them back on the 3rd and then the 7th?
Yes, Your Honor. We do docket day. Yeah.
All right, we'll put you on the 3rd, that's Monday. And then we'll come up with your trial date once we get down to how many are actually going or not. But we're set for the weeks of March 10th and March 17th.
Yes, sir.
So it would be one of those, hopefully you don't get bumped. There's just a lot of trials. We just have to see which ones kind of wash out and how many we have and how much help I have from other judges to fill in. Okay?
Yes, sir.
All right, thank you, Mr. Tatum. Let's see.
Judge, this is Akeem Callaway. Case number is 23 CF 923. On Mr. Callaway's case, he was in court on January 30th because we thought we had worked out an agreement, but Mr. Callaway was in Department of Corrections custody and was brought back on the 30th. I've met with Mr. Callaway and talked to him about it. At this time, he had rejected the offer the state made on the 30th, and so that offer is no longer on the table.
Okay.
We have a couple of witnesses that need to be deposed, so we'd ask for a continuance to finish those depots and then prep it for trial maybe next cycle.
All right. Anything from the state?
No objection.
Mr. Callaway, anything from you? Do we know if Mr. Callaway is going to get sent back to DOC in the meantime?
He has a case up here, and then he has a criminal traffic case in the south end. So I think they're holding him because they served him with the warrant in that case, and then they transported him.
I just want you shuttling back and forth, and then someone forgets
I'll
to
be
bring
here
you the
till I
next
get
time,
finished.
and I just want to make sure we get you here. All right, so Mr. Callaway, we'll see you back on April 30th. They're going to do some depositions on the remaining witnesses, and then we'll tee it up for potential trial that time if that's what you'd like. All right, thank you, sir.
Mr. Chamberlain.
Judge, this is Ladarian Chamberlain. Case number is 23 CF 2420. I saw that the state had filed a null pros on the 24th. So that should be the end of this.
It's my case, Your Honor. Yes, I filed a null pros.
Okay. So you dismiss the trafficking charge?
It's been already prosecuted.
Federal?
Yes.
Right, okay. All right, so is there anything else holding them here?
I don't believe so.
I saw a couple of holds. One is Covington County, Alabama, and one is the U.S. Marshals.
U.S. Marshal, so is your federal case over with?
Yes, I would have been sentenced.
Okay, you've already been, so they're going to bring
He's
you back
sentenced.
over there.
Yeah.
Yeah, he's sentenced already.
I'm just trying to figure out where they're going to send you next, Mr. Chamberlain, but your case here is dismissed, so you won't have to stick around here any longer.
Okay.
All right, thank you, sir.
This is Mr. Chesser. This is Terry Lee Chesser before the court. We have reached an agreement, Your Honor. I just need my client to sign the documents. And Your Honor, he's before the court on 24 CF 2084, 24 CF 2890.
Thank you, man. So it's as charged on all of them? Okay, just wanted to make sure. All right, Mr. Cheshire, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth?
Terry Chesser,
All right.
7368.
And Mr. Cheshire, you're here in 24 CF 2084, charged with 2 counts of possession of a controlled substance and felony driver one license suspended. Those are each third-degree felonies punished by up to 5 years in state prison. You also have 24 CF 2890, fleeing to elude, third-degree felony, driver one license suspended, third-degree felony, same thing, up to 5 years. I've been handed a plea and sentencing agreement that calls for you to plead as charged and receive 9 months Okaloosa County Jail and some costs. Is that what you want to do?
Yes, sir.
Okay. Have you gone over this plea and sentencing agreement with your lawyer, Ms. Rivers?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did she answer any questions if you had any?
She did.
Okay. And are you satisfied with her advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Have you been forced, pressured, or threatened in any way to do this plea?
No, sir.
Okay, you hemmed there a little bit, but then I kind of delayed my thing. Any issues that you want to tell me about why you might have felt threatened to do this?
No, sir.
Okay. Anyone promise you anything other than the terms of the agreement in order to get you to do it?
Well, I'd signed a different agreement there once back when my lawyers has changed due to the fact Mr. Gibbs was the first one. So things have got a little bit mixed around a little bit, but I'm still satisfied.
Okay, you're satisfied, but you don't feel pressure to do this, do you?
No, not really.
Well, then, explain to me what you mean, because here's the thing. I have to take things as kind of absolutes. So if you feel there's some gray area, I have to know what that means, you know, what you think is pressuring you in some way.
I'm good. Thank you, sir.
You're good? You sure about that?
Positive.
If you rethink it before we finish here, just go ahead.
I'm not going to read. I'm good.
All right. Do you understand that if you enter a plea, there won't be a trial of any kind?
Yes, sir. I'm good.
And you'd give up all of your rights to trial that are listed here on page 2 of your agreement?
I understand all of it. I'm
Okay.
good.
Okay. Well, I'm just going to ask a question. I ask the same questions of everybody else. Do you understand you're waiving any potential defenses that you have in these 5 felony
yes,
charges?
Sir.
All right. And what is your plea, Mr. Cheshire?
No contest.
All right. I'm going to accept your no contest plea as to all counts in both cases, 24 CF 2084, 24 CF 2890. In all cases, it's going to be 9 months Okaloosa County Jail, credit for time served, $515 in court costs on the 2084 case, $100 cost of prosecution, $100 PD fee, $50 application fee. In the 2890 case, again, 9 months Okaloosa County Jail concurrent, means they run at the same time. Credit for time served, $415 in court costs, $100 cost of prosecution, $100 PD fee. What I'll do, Mr. Cheshire, is give you 90 days upon your release to go to the clerk's office and set up a payment plan. Otherwise, your costs will be sent to collections.
Yes, sir.
You understand all that?
Yes, sir.
All right. I need you to be fingerprinted, and then I'm going to tell you you've got 30 days to appeal the judgment and sentence of the court. This was a state's agreement and a guideline sentence.
Yes, Your Honor. I believe it is. It is a state's agreement. I believe
43.1 points, so just under scoring prison. All right. Thank you, Mr. Cheshire. Step
Thank
over
you.
to be fingerprinted.
Your Honor, this is Randy Cooper before the court, 24 CF 1832, 24 CF 2513. I have met with Mr. Cooper. One of the issues that had come up was him not having his discovery and being able to see his videos. We have taken care of that. But at this point, we're going to have to set depositions and then go from there. So I'm going to request a continuance.
No objection, Your Honor.
There's two cases. One's just from October. So I'm going to set you on April 30th for your next pretrial conference, Mr. Cooper. And then your, Ms. Rivers, is this going to be yours?
No, Your Honor.
All right, your new lawyer will come and talk to you, Mr. Cooper.
So, no, but I'll talk to Jay about it, and, okay?
Ms. Rivers, is Harrison yours?
Harrison? No, sir.
It's no attorney. Okay. When we finish up some of yours, Ms. Rivers, I'm going to call it Mr. Harrison. So I've got my note.
Yes. Joshua Douglas, Your Honor, 24 CF 1226, 24 CF 1678. Your Honor, same issue, no discovery, no videos. That has since been rectified. There was one additional issue that came up. I have discussed that with the state. She is asking to have this case brought back on Monday to see if we can't work out something.
Awesome.
Okay.
Thank you.
All right, March 3rd, without subpoenas.
Yes, without subpoenas, yes.
Durham, Delroy.
Your Honor, this is Delroy Durham. He's before the court on 24 CF 1417, 24 CF 1419, 24 CF 2412. Similar situation. There was an issue last time of an offer that had not been conveyed, discovery.
50 months DOC, right?
I'm sorry, yes, Your Honor, that's correct. I had shown him the videos in the 24 CF 1417, and I had asked Mr. Gibbs to show him the videos in the remaining cases. He's indicated that was not done. At this point, we are going to request a continuance, and this will, I have advised him of the evolving situation and how we're going to be dividing up the division.
Okay.
He indicated some discord with that, and that's where we're at.
Discord with getting a new lawyer? All right, Mr. Durham, what are your concerns? Speak freely.
Did you want to say anything to him?
About having new lawyers?
Oh, yeah, I thought you appointed me Lisa Rivers January 10th when I came to court.
Well, so the way it works is I appoint the public defender's office. They
Right.
get to choose who represents you in their office, who's assigned
Right.
to your division. It had previously been someone else, but that person won't be in this division anymore. So I think Ms. Rivers kind of jumped on your case to help out, but it may not end up being yours, right? Okay. So I don't get to assign
Yeah,
Ms.
yeah.
Rivers or Mr. Williams or Mr. Russell or Mr. Maddox. They get to choose that part. But you're going to have someone besides Mr. Gibbs.
Okay. Okay.
Anything else?
That wouldn't be for today,
Yeah.
okay? But that could be something that you talk about with your next attorney. You can.
Can I just
wouldn't-
represent myself?
I wouldn't advise it, though.
All right, you'd have to, if you want to, I can set a hearing because we have to do what's called a Ferretta inquiry.
All right.
Is that what you want to do?
Yes, sir.
Okay, knowing that you're looking at a prison sentence, you want to go forward
Yes,
without
sir.
a lawyer?
Yes, sir.
All right, well, why don't we bring them back on Thursday the 6th at 9:30 and we'll do your Ferretta inquiry.
Okay.
Yeah, because I've got another RPO at 9 o'clock, and I just don't want everyone, especially jail people, to be stacked up. We won't be able to start until probably 9:30 anyway.
Your Honor, this is Jelonta Durham. He is before the court on 23 CF 591. Mr. Durham has been shown now videos. He has been shown what I believe to be the relevant portion of the phone downloads. We have depositions set on this matter for April 4th. And so we are requesting a continuance at this time.
Your Honor, I would object for the record. However, I just want to make sure I know which attorney has this case because it's a very serious case. Victim and other witnesses are out of state, and we've been trying to set this case a few times already.
Almost 2 years old.
Yeah.
The victim had not been deposed, that all the people that were there that day had not been deposed. I believe that that is essential if he's going to get effective representation. So, Your Honor, I would ask that we have the depositions on the 4th.
Are those set and subpoenas out?
I don't know if subpoenas are out, Your Honor, but they are set.
How many depositions are we talking about?
Maybe
Ballpark?
5.
5?
Yeah.
All right. Absent some issues with those, I mean, I expect to go to trial next cycle. Mr. Durham, anything you want to tell me? April 30th. I don't expect to continue it again, Mr. Durham, so we're going to try to get your attorney to really get on top of things now that you have someone new.
Espinoza.
Your Honor, this is Nicholas Espinoza. He's before the court on 24 CF 2353. I have provided him with his written discovery. He's been provided that now. We have met. We have gone over the facts of the case. I had contacted the state about a possible different offer, a different resolution of this matter. She was going to get in touch with the victim. She did. They want the state prison sentence. So, Your Honor, this time we're going to ask for continuance to 4:30 and set depositions in this matter.
No objection from the state.
Thank you.
It's going to be April 30th for the next pretrial and see if we can get those depositions certainly scheduled and not completed by then. It's a relatively new case, but.
You said they want my mother. Said she
Mr. Berry? on someone else. I've got mine. Come on. Will you be? Mr. Harrison, I've got probation looking at your case real quick, and I'll call you up once they can figure out their information too.
No, so there's no need to have it on Monday. So
Who is it?
before they get brought in for a bond reduction hearing, okay?
Yes, ma'am.
Yes, sir.
Hey, come on out, Robert. All right, Judge, we're going to go ahead and just announce ready for trial on it. We've taken depositions in it. Doesn't look like we're going to be able to resolve it. So we can set him for docket day. Certainly run it past him and see if we can get it resolved.
All right, my understanding is we got 23 CF 2069, where he's charged with aggravated battery, aggravated assault, deadly weapon, possession of a weapon or ammunition by a convicted felon. Then there's 24 CF 1680, which is a criminal mischief.
The older case is the one, the aggravated assault is the one that we're talking about.
I assume so, but I just wanted to make sure.
Yes, sir. Yes, sir. The other one, I'm sure can be resolved.
Ms. Leone, you ready for trial on 23 CF 2069?
I'm trying to locate the case. I hadn't had any communication with Mr. Williams about this.
Fellow's deposition, he said he was a fighter.
Oh, yeah, yes, Your Honor, we're good.
You ready for trial?
Yes, sir, yes, sir.
Okay. So, Mr. Jones, we'll bring you back on Monday, the 3rd. That's our docket day, just to make sure everyone's ready, got their subpoenas out. And then we'll talk about potentially what week your trial will go, either March 10th or March 17th.
All right.
Any questions for us? All right, thank you. We'll see you back on that date.
Charles Russell, Public Defender's Office, Judge. Mr. Freeman's case is 24 CF 2639. At this time, we're going to ask to continue it. It's the first time up. But let me talk to him in the back before they send him back. But can I do that first? Yeah.
What are they offering me right now?
All right, Mr. Harrison, sounds like you've got some paperwork you got to go get for us. All right, you'll be back in less than an hour, right? Okay, you know, if you're not back in an hour, I'm going to send someone to come look for you, right? All right, we'll see you in a little bit.
I'll sign it right now. I read it. I'm cool with it. Yeah, sir, I want to sign it right now.
Your speed
And if you're not doing anything.
We talked about it that when you came to see me in the jail. I'm aware of what's going on.
Okay, but you hadn't seen this agreement before. Your call.
this is for 1129 probation and
Right
what
here.
we talked about the other day, right?
But you need to read this. But yes, you're going to have to sign it there.
All right.
So read this. So I'm getting everybody to sign.
All right.
Read it. Do you want some time to read this over?
No, sir.
Agreement on this case, state's going to drop the felony in exchange for pleas to misdemeanors.
Yes, sir. All right, Mr. Freeman, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you're here in 24 CF 2631. You're currently charged with possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison. Driving under the influence, which is it's listed here as a first-degree misdemeanor, punished by up to 9 months in county jail. And possession of drug paraphernalia, first-degree misdemeanor, punished by up to a year in jail. Do you understand what you're currently charged with?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that where the state's going to dismiss count 1, the possession of controlled substance, if you enter a plea to counts 2 and 3 with probation and all the mandatory DUI sanctions. Is that right?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer, Mr. Russell?
Yes, sir.
Has he answered all of your questions?
Yes, sir.
Did you understand this form?
I did.
And did you sign it?
Yes, sir.
All right. You satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any? Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement in
No,
order
sir.
to get you to sign it? All right. You understand that by entering a plea, you won't be going to trial, and you'll be giving up all of your trial rights, which are listed on page 2 of your agreement.
Yes, sir.
You understand that you'll be waiving all potential defenses.
Yes, sir.
All right, and what is your plea, Mr. Freeman?
No contest.
I'll accept your no contest plea. It counts 2 and 3, the DUI and the paraphernalia, as to count 1.
No cross, Judge.
Okay. So this is just misdemeanors, but count 2. Have y'all talked about whether or not this is going to be DOC or JCS probation?
Typically state probation.
He had a felony, but it was dropped. It'll
Your
be.
Honor,
It's a
if
DUI. I just figured
if you place
JC.
him on probation right now, we would take the supervision of the probation unless you told me it was through judicial service.
I just want to know if they talked about it because JCS probably does a lot more DUI sanction stuff than y'all do.
They do, but if you send us in, we're sending them to our office.
Well, all right, it'll be DOC then.
Okay, thank you.
All right, counts 2 and 3, it's going to be adjudication of guilt, 11 months, 29 days probation, so just under a year. For each count, those will be concurrent, which means they'll run at the same time. I'm going to waive the cost of supervision. You're to pay standard court costs, which on a DUI are, well, I guess any misdemeanor. 438 in court costs, $500 fine, that's minimum on a DUI. $100 PD fee, you're to perform 50 hours community service, minimum on a DUI. You can buy those out at the rate of $10 per hour or any combination that you might want to do. 6 months driver's license suspension. That starts as of now, not whatever you had before because of administrative. You have to complete DUI school, attend a victim impact panel, impound of your vehicle for a period of 10 days. The court doesn't have any objection to you reaching a hardship, but you make sure to reach out to DMV so they can, or DHSMV, so they can tell you what you need to do. Typically involves at least signing up for, but I believe completing DUI school before you can get a hardship. I'm looking at Mr. Maddox because he's been in county court more recently than the rest of us. I just want to make sure that hasn't changed. So, all right. So, Mr. Freeman, I'm going to need you to get fingerprinted, but you're going to go talk to probation first. Then you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence because it's a misdemeanor. I don't need any guidelines. So.
And the only other thing I wanted to put on the record, Judge, Mr. Freeman has a hold from Alabama, and I've let probation know that, so I don't know how that's going to play out. I'm thinking they're going to ship him there before they actually let him out of jail.
I wasn't aware. All right, so make sure that once you get out of Alabama, where in Alabama?
Freeman, do you live here?
No, sir. I've been living in Alabama.
I didn't write it down. Do you know what county your hold is from?
Should be either Covington or Baldwin.
Okay.
It sounds like this is better served to go to maybe JCS probation. JCS is county probation. And since it's a misdemeanor, I can do that. And they work out of state a little bit better. Mr. Maddox?
Well, they won't let him transfer probation officers over there. My understanding, and they have had difficulty in the past maintaining reporting due to the distance.
Okay, I thought it was more, it's not a transfer as much as they just report by mail or phone or whatever.
That's usually fine.
So there was a hold.
And, Your Honor, because it's a misdemeanor, in 1129, he can report by mail if the court orders it.
You can wait.
Sorry.
I just don't want everyone to talk at the same time. Do you mean if he's with DOC, he can do mail-in?
Because it's a misdemeanor.
Turner?
I thought
It has to be reporting probation if it's a DUI.
Statutory is reporting probation.
That's all we know.
All I know is if it's for a misdemeanor.
Sometimes we ask.
I feel like I'm
so
taking
many
the LSAT
questions, we get
again.
answers.
Well, I'm going to keep it at DOC probation, but you're going to have to report back. Where are you going in Alabama?
I'm going to Opp, Alabama. That's after I deal with them up there.
You're going to have to come back here to report back.
I'm
I would
aware.
say within 72 business hours of your release from Alabama, the jail, wherever you're at, you need to come down to the Department of Corrections probation office here and check in with them so they can help you if they're going to try to do interstate compact or what. Will they even do interstate compact for a misdemeanor?
We'll make it work, Judge. If it is interstate compact, he will have to pay $100.
Okay.
We can give him a travel permit to go home. All that since it's a misdemeanor.
All right.
It's like
Just make sure, Mr. Freeman, within 72 hours, business hours of you being released, you head down to the probation officer here in Crestview.
Either from here or the other jail.
Once you're out of jail, as a free man.
Right.
Mr.
Yes, sir. I get it.
All right. I didn't mean that until it came out. Okay. All right, any other questions?
No, sir.
All right, thank you. Make sure you talk to probation first, though.
Thank you, Your Honor.
Back up to cops.
Judge, this is Jasmine Cobb. Case number is 24 CF 2587. I believe we have an agreement. If I could have a moment.
I'm serious.
I have a plea agreement and a score sheet if I may approach, Judge.
So just to make sure I understand this, Mr. Russell, it says 90 days, pay any money owed within 90 days, but then it's reserved jurisdiction on restitution for 90 days. So the money owed, you're talking about court costs and
Court costs and
fees.
PD fee, Judge.
Okay. All right, Mr. Cobb, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you're here in 24 CF 2587, charged with 1 count felony petty theft, third degree felony, punished by up to 5 years in prison. And count 2 is resisting a retail merchant, which is a misdemeanor, punished by up to a year in jail. Do you understand those things?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that calls for you to enter a plea of no contest and be adjudicated guilty with 120 days county jail and some costs and things like that. Is that what you want to do today?
Yes, sir.
Did you go over this form with your lawyer, Mr. Russell?
Yes, sir.
Did you read through it and sign it?
Yes, sir.
Did you understand it?
Yes, sir.
Did he answer any of your questions if you had any?
Yes, sir.
Are you satisfied with his advice and
Yes, sir.
representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir. I'm in work pod.
You're what?
I'm in work pod in the
Okay.
kitchen. So.
Is that what the different outfit is for?
Yes, sir.
Okay. And where was I? Are you suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Has anyone promised you anything in return for this plea?
No, sir.
You understand if you enter a plea, there won't be a trial of any kind, and you'll be giving up your rights to a trial that are spelled out on page 2 of your agreement. Right to plead not guilty, right to a jury trial.
Yes.
You understand we're not going to have a trial if you
Right,
enter a plea.
Right, I understand.
Okay. And you understand you're waiving any potential defenses that you may have. Okay. And what is your plea?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on both counts. To be 120 days in county jail for each count concurrent. That means they run at the same time. Credit for all time served, $515 court costs, $150 PD fee, no trespassing, no return to the Five Below in Crestview.
Yes, sir.
Okay. Pay any money owed as far as those costs within 90 days of your release. I'm going to order restitution, reserve on the amount of I guess Five Below says they're owed any other money, and you don't agree to that number, we'll come back for a hearing, but otherwise I have to do that within 90 days.
Yes, sir.
All right.
Thank you, Your Honor.
This is a guideline sentence and also the state's agreement.
Yes, Your Honor.
Okay. All right, Mr. Cobb, you've got 30 days to appeal the judgment and sentence of the court. I need you to be fingerprinted, and then you'll head out. Thank you, sir.
Judge, this is Horace Durden. Case numbers are 22 CF 178, which is a VOP, 22 CF 2587, which is a new law violation, and 24 CF 2762, which is a new law violation. It's a first time up for the brand new 24 case, so at this time we're going to ask that all cases be passed. The last offer in the case was 80 months DOC.
How many months?
80 months.
Okay. I thought you said 8, and that didn't make sense to me, so I wanted to make sure you.
Yes, sir.
heard
It's
you.
80, but we're asking to continue all cases so we can take depositions, prep for trial.
Any objections?
I just want to say, Your Honor, the state is ready on 22 CF 2587.
And on that case, Judge, I saw that 7 out of 14 witnesses have been deposed, so I don't know about the other 7 witnesses that weren't deposed, but that's what I noticed when I went through that file.
So this case is from October of 22, and depositions have not been completed. Obviously, new counsel is going to work to get those done quickly. Mr. Durden, we're going to put it on April 30th. I understand the state's objecting to continuing this case again. Due to your constitutional right to effective counsel, I'm going to have to make sure it gets continued so your case can be properly investigated.
Thank you, sir.
All right, we'll see you back April 30th, Mr. Durden.
Your name?
Fountain.
Jared Fountain.
Yes, sir.
Judge, this is Mr. Fountain. Jared Fountain, case numbers are 24 CF 2726, 24 CF 2780. This is the first time up, so we're asking for a continuance.
No objection.
All right, April 30th, Mr. Fountain. Your lawyer will come out and talk to you about their case, and we'll see you back on that date. Thank you. They just got a lot more. I heard. Always stall for a second.
Oh, okay. Espinosa's. See. All right.
Charles Russell Public Defender's Office, Judge, this is Wanda Carpenter. Case numbers are 24 CF 909, 24 CF 1124. I met with Ms. Carpenter based on discussions. We're going to do a competency/sanity evaluation. So at this time, depositions have not been done. Offers 36 months DOC. So for all those reasons, we're going to ask for continuance to the next pretrial conference date.
No objection. But I do have a question. Is Mr. Russell, are you going to be conducting the depositions?
Say that again.
Are you going to be conducting the depositions?
Some of these older cases I may have to take. I don't know if this is one of them.
But you'll ask for the dates and get them scheduled?
Yes.
Okay.
She's got 2 cases, right? All right, it's going to be April 30th for Ms. Carpenter on both of her cases. Ms. Carpenter, someone's going to come out and talk to you to give you an evaluation, and we'll see you back on April 30th to talk about
Thank you.
that.
Yes,
All right.
sir.
Judges, Winona Carpenter, case number is 24 CF 2045. I believe we have an agreement, if I can just have a second.
Adjust the paper however you need it.
Mm-hmm.
Okay, Judge, this agreement calls for a plea to a misdemeanor. State drops the felony, so there won't be a score sheet. May I approach?
Ms. Carpenter, can you raise your right hand to be sworn? You're good. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Carpenter, you're here. Can you state your name and date of birth, please?
One on the gay Carpenter, 3169.
Okay, and you're here in 24 CF 2045, charged with possession of a firearm by a convicted felon, which is a second-degree felony and punished by up to 15 years in a state prison, and also possession of drug paraphernalia, which is a first-degree misdemeanor punished by up to a year in county jail. Do you understand that? That's what you're currently charged with, right? Yes?
Yes, sir.
All right, I see you nodding, but I need you to say it out loud. All right. So I have been handed a plea and sentencing agreement that calls for the state to dismiss count one in return for you pleading to the paraphernalia charge for an adjudication of guilt in 180 days in county jail. Is that what you want to do?
Yes, sir.
All right. Did you go over this form with Mr. Russell?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for entering this plea?
No, sir.
Do you understand that by entering a plea to the paraphernalia charge, there won't be a trial of any kind?
Yes, sir.
And do you understand you're giving up your trial rights, which are on page 2 of your agreement here?
Yes, sir.
And do you understand you're waiving any potential defenses you may have?
Yes, sir.
And what is your plea as to the paraphernalia charge?
No contest.
I'll accept your no contest plea as to count 2, count 1.
The state dismisses count one.
Okay, state's not processing count 1. Count 2, it's going to be adjudication of guilt, 180 days county jail, credit for time served, standard court costs, which would be $270 for a misdemeanor. $100, well, I guess the PD fees, it's 50 and 50 for the application, right? So that's
Yes, sir.
100. Okay.
Yes, sir.
May perform community service work at $10 per hour for eligible court costs. Okay. And make sure you set that up with the clerk's office, a payment plan, or to do the community service within 90 days.
Okay.
Okay. All right. You've got 30 days to appeal the judgment and sentence. I don't think any of your fingerprints is just a misdemeanor and it's not enhanceable. So, all right. Thank you, ma'am.
Thank you.
Okay, that's right. Mr. Espinosa wants to do one as well.
Mr. Russell? Had that plea form gone back there or something?
That's why it was in that condition, yes, sir. It wasn't that in shape when I sent it back there.
Oh, is this going to be like gross or something? If I can find one of the old COVID ones, that's just. I can't even handle
Yes, sir.
this.
Thank you.
Strawberry shortcake, all those.
Judge, this is Adrien Foreman. Case number for the record is 24 CF 2592. We've worked out a plea agreement. It is a guideline sentence, and I have the score sheet and a plea agreement, if I may approach. She's
Yes, sir.
on page 49 of my docket.
Yeah, it's page 94 of mine. I've still got Monday's docket with everything on it because I already put all my notes on it and I want to start over, so. All right, Ms. Foreman, can you raise your right hand, please? Do you swear or affirm? You're okay. You don't.
Sorry.
It's funny because it's like I got to see a certain part of your hand. I don't even know why we do this sometimes, but do you swear or affirm that the statements you're about to give are the truth, the whole truth, and nothing but the truth?
Yes, sir, Your
All
Honor.
right, can you state your name and date of birth, please?
Adrien Foreman, 3/10/1992.
All right, Ms. Freeman, you're here in 24 CF 2592, where you've got 6 counts of illegal use of personal information, second-degree felony, punishment up to 15 years in state prison each. Count 7 is fraudulent use of a credit card, 8 burglary, unoccupied conveyance, 9 criminal mischief, 10 grand theft, 11 theft of a credit card, 12 fraud, possession of personal identification info. Do you understand all the current charges?
Yes, sir.
And this calls for you to do 22 months in the Department of Corrections, is that right?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right, I've been handed a plea and sentencing agreement. Have you gone over this with Mr. Russell, your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with his representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
And as far as if you enter a plea, you understand there won't be a trial of any kind?
Yes, sir.
Then do you understand you're waiving all your trial rights, which are on page 2 of the agreement you signed?
Yes, sir, I do.
All right. And what is your plea to each of the 12 charges?
No contest, Your Honor.
I'm going to accept your no contest plea is freely, voluntarily, knowingly given. In counts 1 through 8 and 10, which are the felony cases, it's going to be adjudication of guilt. 22 months in the Department of Corrections, credit for all time served. Court costs will be $515, $150 PD fee, no contact with Natalia Reese Fredrickson. Reserve jurisdiction on restitution for a period of 180 days. Any money that you owe as far as costs will be owed to a judgment. And then on counts 9, 11, and 12, which are the misdemeanor counts, it's going to be adjudication of guilt and time served. Do you understand that?
Yes, sir.
Is this the state's agreement?
It is, Your Honor.
All right, and it looks like the score sheet is 21.9. This is 22 months, so it's a guideline sentence.
And Judge, did you say concurrent or?
I don't think I did. It didn't say it on there, but all the time is concurrent across all cases, or all counts. All right, so Ms. Foreman, you've got 30 days to appeal the judgment and sentence of the court, but I need you fingerprinted before you leave.
Yes, sir. Thank you.
Thank you. Have a good day.
Judge, the state and I have jointly agreed to continue the case.
Give it just a second. You said this is Jones?
That's correct, Judge. Robert Zukis Jones. If the court needs, we can approach.
No, I've got it. I just wanted to make sure I didn't have any notes on the case, and also I can mark it. All right, April 30th for your next pretrial conference, Mr. Jones. Is that a new jumpsuit? It's pretty vibrant compared to the ones we normally see. All right, thank you, Mr. Jones. We'll see you back on April 30th.
Thank you, Judge.
Afternoon, Ms. Gainey.
Judge, can we leave this on for the 3rd? I think we may be towards a resolution on it, but I need to talk with Ms. Leone. Received information from another source, Dana Claw.
Yeah, but I'm not agreeing to that, unfortunately.
You want to talk for a second or no?
I don't think, we can just set it for next pretrial, Your Honor, for purposes of today.
My problem with the case is, last time we were here, Ms. Gainey, who's filed numerous pro se motions, she really wants to have a suppression hearing regarding her traffic stop, right, Ms. Gainey?
Sure.
And she indicated last time she was here that she's been in jail for approximately a year.
Over a year
And has seen her attorney one time. So I would like, if y'all could talk about if there's a potential resolution, or Mr. Williams, if you want to.
Your Honor, she's charged with 2 trafficking charges.
I understand, but I don't want to just continue it.
Yes, sir.
Because I want to know, at least, are we going to get, is the public defender going to adopt her motion to suppress or file one separately so we can get that heard at least? I don't want to say anything more than that, but obviously Ms. Gainey is wanting to get her case progressing, which it hasn't done in over a year.
I have reviewed the case that she provided. I do want to go, I've reviewed the videos. I do want to go look at the scene briefly. Some of it has to do with the location, whether it's a business area, which I believe that it is. It's the taco town down the street.
Well,
and I need to explain to her about the case law. But if the court wants to go ahead and set a motion hearing, it's always easier to cancel time than to.
I don't want to set a motion hearing. I want you to find out if you're going to adopt her motion or file one, because, so I think I explained this last time, Ms. Gainey. If I didn't, I apologize. We deal with a lot of cases. I can't remember all the facts about every one. But when you're represented and you file something, unless your attorney adopts that motion, I can't do anything with it. So that's why I'm asking if they're going to adopt it or file their own, where they may say, you know what, this is a good issue. I'm going to go ahead and file one, the normal way they do it, as opposed to, the handwritten ones that you filed. I know you filed at least 3 in the past couple of months that are about the same issue. I haven't read every single detail about them, but I've seen them.
Judge, I would rather talk with her about her interpretation of that case than talk with the court and potentially, if after talking with her, I decide to adopt the motion.
I just don't want to set a motion hearing if we don't have a motion.
Yes, sir.
So you can certainly set one as soon as you want one, but.
So if we can leave it on for the 3rd, which was my original request, I think the state was the one that wanted to set it out. And what I will do is I will go out to the jail and talk to her again and go over the case that she provided. That will also give me a chance to go by the scene and make sure that my assessment of the area and how it relates to that statute is correct.
Let's leave it on without subpoenas for the 3rd. Mr. Williams is going to come talk to you now that he's on your case, and they'll decide if they want to set it for a motion hearing or not. I just don't want you to go on the back burner because I think you've been waiting too long as it is.
Okay.
March 3rd.
go over that.
Where they're saying, I mean.
Okay.
Okay.
Today's not the time and place to do it. Shelby Green?
That's fine.
Okay.
I was gonna say that's South Russell Public Defender's Office, Judge. This is Shelby Green. Case number is 24 CF 1790. If I could have a moment. Judge, at this time, depositions have not been taken in her case. She scores state prison, so at this time, we're going to ask for a continuance to take depositions and prep for trial.
No objection from the state.
We'll see you back on April 30th. Mr. Green, the case is getting on the older side. Mr. Russell, I know you're new to it, but let's see if we can get that set.
Yes, sir.
Mickey Grimes.
Judge, I'm going to ask that this be left on for 3-3 without subpoenas. We're attempting to negotiate a resolution in the case.
I thought we talked.
All right, anything from the state on that? Leave it on without subpoenas for a possible resolution on Monday.
Yeah, that would be fine.
I won't get upset. I'm not upset with anybody. I just want to make sure we can handle things the right way, and you aren't speaking in front of a live microphone about confidential, privileged information.
It benefits me to throw someone else under the bus on that one, Judge. Sorry.
It shouldn't be the court, though.
Special delivery.
Who's this going to be under, Miss Rivers? You?
Your Honor, this is Kenneth Osborne, 16 CF 1542.
Is that going to? Well,
Fine, Your Honor.
oh, there it is. All right. Go ahead.
Your Honor, Mr. Osborne has requested numerous items to be transcribed and to make contact with his previous attorney, Burt Moore. We're going to request a continuance.
You can get in touch with his old lawyer?
Without objection, Your Honor, I know Ms. Rivers has been working this one with him.
This case is back on a 3850 because someone didn't preserve a motion to suppress, right?
That is correct, Your Honor.
This is what I'm talking
We're
about.
talking about preservation
This is
issues
what I'm
earlier.
talking about. All right, Mr. Osborne, I'm going to have you come back on April 30th. Ms. Rivers, are you staying on this one then?
Yes, Your Honor.
Okay, so Ms. Rivers is working on your case now. I guess you've been on it for a little bit.
Yes, Your Honor.
All right. You have contact information for Burt Moore?
I did just recently get contact information.
I think I run into him more than any lawyer I know. Just random places. I'm not sure what that says about either of us. All right, we'll see you back on April 30th.
Thank you, Your Honor.
All right, thank you.
Shalom.
Okay.
Mr. Dice.
Austin Geis.
Yes, sir.
Judge, this is Austin Geis, case number is 24 CF 2576. Mr. Geis has another case, a brand new one that's set for plea day on March 27th at 1:30. So what I'd propose to do is, the case that's on the docket today is a first time up, but I would ask to set it for March 27th at 1:30, and then we'll see what we can do about both cases on that day.
Oh, wait, if I may say,
Judge, I stand by my original request. Pass this case to March 27th, and hopefully we can resolve it.
All right, March 27th.
1:30, Judge.
1:30.
The other one's set for felony plea day.
Mr. Geis, we'll see you back on that date for both of your cases.
Yes, sir, thank you.
It has to pass her. Are you ready?
Hello, Mr. Parker.
What?
To set it for,
You want to do it?
it's what,
I mean. Probation?
she's offering. So, on Gerald Parker,
Okay.
Um,
6 months credit time, sir?
I would like to speak with the victim about that before I make any definitive response. So we could leave it, I mean, I don't know if Your Honor wants to put it on for Monday.
You think you can get in touch with the victim that quickly?
I don't know, I mean,
I would say let's try.
we can try. I don't, so,
Let's go March 3rd,
6 months.
docket day without subpoenas for a possible plea.
well, I can at least respond to the counteroffer, Your Honor.
Okay, we'll see you on Monday.
All right, thank you. So it's 6 months,
don't know yet. We'll
Oh.
find out on Monday.
Monday?
Mm-hmm.
I'll go ahead.
Mm-hmm. Your Honor, this is John Paul Paris before the court on 2009 CF 1958, 2009 CF 2392, 2009 CF 2515, 2024 CF 2737, 2024 CF 2738. We filed a motion of conflict back on February 11th. Huh?
I need to talk.
All right, do you understand, Mr. Paris? That means I'm just going to have to appoint you a new lawyer from a different agency.
I do understand, Your Honor. If it is okay with you, Your Honor, I'd like to address the court.
And Your Honor, this would need to not be regional conflict counsel because you just appointed something that would cause another conflict if it went to RCC.
Well, the problem is I have to do it to RCC, and then they'll have to file something that says they have a conflict. And then once they do, I'll end up appointing you a private lawyer who takes appointed cases.
So what do you say? It will temporarily. And Your Honor, Mr. Paris was wanting to handle his case right away, but I explained to him that due to the conflict, and he understands the conflict, that it can't be addressed right away. That's part of his frustration.
What's the current plea offer that's been made?
The DOC offer, Your Honor, for all, concurrent with all cases. There are,
I just want to know kind of the gist of it. All right, so I've signed the order appointing RCC. If they have a conflict, they'll have to file something. Ms. Rivers, if you can maybe drop them a line, that way we can get you someone appointed. I have to do it in that proper sequence, otherwise it doesn't really work well for the lawyer who's ultimately going to get appointed to you, because they have to have all that paperwork in line before I can do that. And until they actually tell me that.
I respect that, Your Honor. I understand what's going on. I mean,
there's been times where I know of all the conflicts because I've just appointed the people to a co-defendant or something like that, and I'll literally say, I'm appointing you a public defender. I know they've got a conflict, so I'm gonna let them withdraw. I'm gonna appoint the RCC. I know they've got a conflict, so I'll let them withdraw, and then I'll appoint someone else. And it's one of those things that we have to do in court that seems kind of silly, but it has to be done the way it's supposed to be done.
Yes, Your Honor.
All right, thank you, sir. We'll see you back on April 30th.
Hello, Mr. Phelan.
How you doing?
All right. Your Honor, this is James Phelan. He's before the court on 19 CF 2175, 19 CF 2215, 22 CF 2949, 24 CF 2472. We do have depositions set in 24 CF 2472 for May 30th.
May 30th?
Yes, Your Honor.
State's doctor. How many times did you try to contact him before we had this?
5 myself.
What are you asking for, Ms. Rivers?
Your Honor, I did ask to continue the case to the 4:30 docket.
Just because that's a month before the deposition.
I know.
That's
I
fine.
know.
April 30th.
Your Honor, may I ask, please, to set the VOP cases on any miscellaneous date after March 27th?
After March 27th?
Yes, because March 27th, I won't be able to gather all the witnesses that I need for the VOP.
I think the next one I have is May 29th.
That's the first miscellaneous after March 27th?
I mean, we have a lot of those Thursdays after arraignments type those, but those aren't technically miscellaneous dockets. Those are just,
If we could set it for one of those, it would be fine for me.
well, is the VOP based on the case where the depositions are being done?
Yes.
I'm just not sure how, if they haven't deposed the witnesses who are going to testify potentially at that VOP.
As probation officer and the officers who did the investigation.
Are there, well, I understand that, but they have to be able to talk to everybody first.
I'm not sure, Your Honor, about the discovery for a VOP, if they're entitled to depositions.
So you're saying they shouldn't be able to depose people who are going to come in and testify and put them in prison?
For a VOP hearings, I don't believe they have a right to depose the
But
witnesses.
they're deposing them anyway.
I understand that, but I would like to resolve the VOPs, possibly.
Well, I understand that, but I mean, it doesn't, if they're going to depose them anyway, I don't understand what the hurry is on the state's concern. I mean, this is a case from October 24th.
I understand, but the VOP cases,
Are based on a new law violation from
Understand, Your
October.
Honor.
All right. If you want to take May 29th, we can put it there, but I'm not going to have a hearing where they don't get to talk to anyone and then have them talk to them a couple of weeks later. It seems very counterintuitive. April 30th.
See what type of deal
If
they
you want
want.
to set it for that, we can, but for the May 29th day. But if they already got the deposition set, just let them have them.
Thank you, Your Honor. Thank you, ma'am.
We did Riggs, right?
I'm sorry?
We did Riggs.
Yes, Your Honor, we did.
For some reason, didn't cross it off.
Your Honor, this is Bradley Simmons before the court, 24 CF 2626. Previously, when he was in court, he had indicated that he was going to be hiring private counsel and that his family was going to try to hire private counsel.
Mr. Simmons.
I'm doing all right, sir. You doing all right today, sir?
Say again?
You doing all right today, sir?
I'm doing great.
Can I ask you a question? If you don't mind? Okay. All right. She's a nice public defender. But see, I did my time for the charge I did, and I was on probation. I got out, and I like taking.
What's the question?
Well, just like, can I get reinstated? I'll reinstate it.
That's
I
not
don't
what we're here for, sir.
I know, but I'm trying to.
This is a brand new case.
Yes.
24 CF
violation.
2626, where you're charged with possession of cocaine.
Yes, sir.
So what am I going to reinstate you to? You
Okay.
haven't pled. You haven't been tried.
Okay, can I ask you another question? When they pull me over, I didn't have my
Yeah, he doesn't want you to talk about
Don't
the
talk about the facts of your case.
Okay, yes, sir.
Everything in here is recorded. The prosecutors are sitting right there. They're writing down everything you say if it's bad for your case. You've got an attorney. Are you going to hire someone else?
I'm trying to.
Okay, well, here's the thing, and I've said this at least twice today, I think. When you tell me you're going to hire someone, that typically what happens is your appointed lawyer says, well, do you want me to work on this or not? For example, if Ms. Rivers, your public defender, sets a bunch of depositions and does those, and then you hire someone else, that person may not be able to go back and do those depositions. So Ms. Rivers is not going to want to have those depositions done because she doesn't want to do that to your next lawyer. So you got to really make a decision pretty quickly if you want her to start working on your case or you want to wait another couple of months to find out if you end up hiring somebody else. You have the right to hire whoever you want, so as long as they're a licensed attorney in the state of Florida to represent you. But you have to make also a strategic decision as to whether or not that's a good thing to put off. Okay. I'm not telling you what you should do or shouldn't do. I just want you to make a decision that's beneficial to you and your interests.
Can I ask her one question real quick?
Go ahead.
Okay. All right, we'll see about sending that in. Okay? Your Honor, we're going to request a continuance to the 4:30 docket, and I believe he's going to allow me to
Matter of fact.
proceed on the case.
Can you tell him I'm going to try to hire a lawyer?
Oh, well, Your Honor, now he's back to, he's going to hire a lawyer.
I'm going to try to. Yeah. Well, I'm just.
All right, but again, let me just point it out, Mr. Simmons, you're in jail, right?
Yes, sir.
This case is holding you.
Yes, sir.
You got to make some quicker decisions. I'm not telling you what to do, but again, Ms. Rivers is not going to, take things away from your next lawyer by doing them now, because that's what you're telling her to do. All right, we'll see you back on April 30th.
Mm-hmm.
Judge, real quick on Mr. Simmons, isn't there another case tracking?
He has a violation of probation
The
case.
14 CF? And maybe one other.
Where is that?
So when we're going to reschedule him for 4:30, I want to make sure we get those tracking.
Where are they now?
They're pending in this division.
Yes, Your Honor.
I'm looking at it right now. I just don't see it.
You had set it out, the VOPs out to a different date to give him opportunity to hire an attorney.
I get a bun on it again.
What date did I set it out to?
That I don't have in front of me, sir.
March 27th.
March 27th, okay.
Amen. You cannot,
Is that just a regular VOP? It's not evidentiary.
No,
You ask them?
it's not an evidentiary. There's two of them. One is, I think, a 2014, and I think the other one's a 2015, if I'm not mistaken.
That's correct.
And I was going to just put on the record that when I was calculating the global score sheet for all three, it's a relatively rare instance where the statutory maximum is exceeded by the minimum guideline score. So I believe the law would mandate that what he scores guidelines, it would be mandatory in his.
What's that number?
123 months.
All right.
Just for the record.
Oh, I appreciate it. All right, thank you, Mr. Simmons.
You can have to do.
Mhm.
And that may be, I was just speaking off my mind. I have the 14 case number. I typically would have written them both down. I don't.
The only reopened one I see is the 2014.
And I stand corrected on that, Your Honor.
You want me to put your cases together on that April 30th date, or you want to come back on March 27th too?
Yeah, I'm trying, I'm trying, sorry, sir. I was trying to see if I can get a bond.
That's not why we're here. You haven't filed a bond motion.
Okay, I'm new to this, sir, so.
And frankly, that's another thing. If Ms. Rivers files the bond motion for you, and I'd consider it, and say I were to deny it, when whoever you hire comes in, they have to show a substantial change in circumstances since the last bond hearing. So if you have one lawyer do it, the second one doesn't just get another shot at it. So it's important that you talk to your lawyer about these things as to what you want to do, or do you want to wait around to possibly hire someone else to do what she can do. All right, I'm going to put both your cases on April 30th, Mr. Simmons, but you've got to make some decisions as to what you're going to do.
That's next month?
Almost 2 months from now. If you hire someone else, or you talk to Ms. Rivers and you decide to put it on another date for whatever reason, we can do that. Otherwise, you need to make some decisions as who's going to be representing you and what you want them to do for you.
So if I want to go to the drug rehab, can I just
talk to your lawyer and see if they can get that worked out. Your only other option, I don't negotiate. That's not what my position is. Yeah. They either negotiate something and that's what your result is, or you plead to me and I make the decision completely. Most cases, in fact, 95 to 99% of cases are an agreement between your side and their side. It's very rare that I actually make the decision as to what someone's sentence is. It's usually someone who's gone to trial or someone who pleads straight up to the court. Most things are determined by a plea bargain. So I'm not going to negotiate with you right now, Mr. Simmons. Talk to your lawyer, and we'll get moving on your case, April 30th.
It'll be after trials, the trial cycle. No, he's there. Your Honor, this is Julia Sledge, 24 CF 2745. He has been provided with discovery and shown videos. My understanding from Mr. Gibbs is he's indicated he's going to be hiring private counsel.
All right, Mr. Sledge, when do you plan on doing that?
Thinking this was a bond hearing first. I was trying to let the bond hearing get over.
Not a bond hearing, it's a pretrial conference.
What happened to the bond hearing?
Has a bond motion been filed?
You told her to file a motion last time I was in here.
I don't usually tell people to file anything. In fact, last time I see you had a court date was December 26th. That wouldn't have been me.
Let's say bond hearing. Ain't true.
What's your current bond, Mr. Sledge?
Well, I had a bond, but they dismissed some charges, but she amended some other charges that she put back on, so I got a no bond on it. She dismissed 3 and 4. I mean 5 and 4. I think it was possession of a firearm and aggravated battery. She dismissed it. It say no action, and then I get some papers in the mail that say it's been amended and it's put back on there.
Hold on a second. Maybe I was wrong about that. I might be looking at the wrong case. Okay. I'm sorry. You were in front of me once before. I was looking at the wrong one. From what the notes I see, the information was amended because it was attempted. It shouldn't have been. It was supposed to be attempted, and it was listed as homicide.
Your Honor, if I may, I believe he's referring to the first amended information that added the charge.
That was Gunnar Terrick that she dismissed the other charges on in December. It was 4 and 5, and he gave me a bond on the other 1, 2, and 3. And
all right, Mr. Sledge. Let's kind of get the horse before the cart here, I guess. Are you hiring new counsel, or?
I plan on being crunk. Yeah, I plan on it, but I was trying to see.
Have you talked to his office?
Yeah, we're working on something because I was waiting on them to bring me all the stuff because I don't know if I'm missing some stuff from them. I'm missing like the FDLE report, and they were supposed to bring the videos, and I was trying to see what the bond hearing was going to do first.
I don't see a bond motion filed.
There was no bond hearing requested, Your Honor, and Mr. Gibbs indicated that he did show the videos to Mr. Sledge last week.
Did you see the videos with Mr. Gibbs?
It was altered, so I just left.
It was altered. So
Yeah, it was altered. I know it was altered. It's okay, but you know, like I said, I've been waiting on the bond hearing because, like I said, I was in here last time. You told her when we was talking, you said send you a motion for a bond hearing on some charges that I think she put back on there.
We had a pretrial detention hearing, right?
Yes, Your Honor.
But I have a no bond on an aggravated battery and possession of a firearm that they no action me for. So.
All right, sir, you had a pretrial detention hearing in December, right? In front of Judge Gonteric.
Yeah, December.
So I'll let you talk to whichever lawyer you're going to go forward with, but you've had a pretrial detention hearing where these things were determined.
So can you tell me, do I have a bond? I mean, what?
Judge Gonteric, when he held your pretrial detention hearing, continued it until, well, let me see the next date. 12/12. Count 1, which was the attempted homicide, $350,000 cash or professional. Count 2 was $20,000. Count 3 was $50,000. Now there's an amended information that has new charges, so he has to be arraigned on those.
Yeah, maybe he's referring to the fact he may not have a bond on the new charges, so we can easily.
What is you have? Cash or professional bonds on counts 1, 2, and 3, but you also now have counts 4 and 5, which you haven't been arraigned on.
Yeah, that's what I'm saying. They had dismissed them the first time I came in front of Gonteric, so I was trying to get out, but they said they had amended something.
Dismissed 1 or 2 or 3, so you still have those bonds.
No, I'm talking about 4 and 5.
Sledge, are you going to be able to pay your bonds on those? Do we have to have an arraignment on that? Is that set?
I don't see it set yet, Your Honor.
There's an amended information with new charges. Am I wrong on that?
No,
you're not wrong.
Because only 1, 2, and 3 are talked about in the pretrial detention hearing.
Guess we can arraign him today on those?
Please.
Once they provide it. They haven't provided it yet.
Oh, okay.
Gives it to you everything that she has at the time.
Oh, okay. I just wondered.
Initial information. Okay, I've got them all now. All right, so just to make sure we're all clear. December 11th, information, attempted first-degree premeditated murder with a firearm, tampering with evidence, and false imprisonment were the 3 charges. Then, on January 8th, there was an amended charge, or amended information. It says first-degree premeditated murder with a firearm, which is obviously wrong. It's supposed to be attempted. Tampering with evidence, false imprisonment, and then the new charges of aggravated battery causing great bodily harm by possessing and discharging a firearm, which is a 1020 life case, and then added number 5, possession of a firearm by a convicted felon. Then, an amended information was done on the 14th of January, switching it back to attempted first-degree premeditated murder with firearm. And again, there just seems to be a Scrivener's error on the second one. Mr. Sledge, I'm the one that's speaking. You don't need to try and stare down the prosecutor the entire time. Well, I'm talking. Why are you staring at her? Tampering with evidence, false imprisonment, aggravated battery. So everything's right. They just had to switch it back to attempted. So you've never been arraigned on 4 and 5. What would you like to do at this time, Ms. Rivers?
Your Honor, if the clerk is able to provide it, we could enter a not guilty plea to that at this time.
Provide. Print out a copy of the most recent information from January 14th.
Willing to entertain bond on those 2 counts at this time or not, or to set it on a separate date?
Your Honor, the set would be fine if you wish to set it.
Well, I guess, Mr. Sledge, are you asking for a bond hearing on your other 3 cases? Or your other 3 charges?
I'm just trying to figure out what's the bond is, because that's all I'm trying, and get a bond. That's it. If I'm supposed to have, because I remember last time, like I said, if the record would reflect, we was talking, and you told Ms. Hurt, you told her to send you information of filing a bond hearing about.
Well, that's what I'm trying to ask you now. Is that what you want?
Yes, sir. Yeah.
All right. So what I can just do is leave 4 and 5 as no bond. You file the bond motion, we'll have a bond hearing. How quickly would y'all like to do that?
I thought you would.
Let me just tell you one thing, Mr. Sledge, and this is not advice, but I have to make sure you understand this because you've talked about hiring another lawyer. Mr. Sledge, if you go forward with a bond hearing and I make a determination and then you hire another lawyer and they file another bond motion, they're going to have to show a substantial change in circumstances from the first time I addressed your bond. So I want to make sure you understand is you don't get a shot at it with Ms. Rivers as the public defender and then hire someone else and ask for another bond just because you've got a new lawyer. So do you want to go forward with a bond hearing with the public defender's office, or are you hiring someone else to do that?
I just hired somebody. I don't even care about the bond no more. It don't make no sense. This shit don't make no sense. You give me some charges, but I got to go through a motion to have a bond here, and I thought you would bring.
That's what bond motions are. When people say go through the motions, that's the motion.
Charge me with something. You're supposed to bring me and give me a bond on these type of charges, don't you? But never mind. Like I said, I understand where y'all coming from. Hopefully you don't feel like I have a problem with you.
I think you do.
you know.
You
But
just want to be heard. There's been some confusion, and so you're
a lot of confusion.
understandably frustrated by the situation.
I'm not frustrated. I'm gonna get justice. It's gonna be served one way or the other.
Frustration's not a bad thing. I get frustrated every day.
When they file false paperwork and lie and then alter evidence, somebody gonna get it. They're gonna go to jail. I want them to feel the same when they standing up here. When they family have to see that people lied on
I'm not sure what you're referring to at this point, Mr. Sledge. Do you want to go forward on a bond hearing?
It don't make no difference to me at this point.
All right. Any objection to a bond hearing tomorrow for Mr. Sledge? That way everyone has had 3 hours notice, which is required by rule.
Well, Your Honor, there is a victim involved in this case.
Okay.
Who has serious bodily injuries because of the shooting. And I have a duty to notify at least. And I may not have time between now and tomorrow.
Same person that I got attempted on, ain't it?
The other, if I may, Your Honor, though, one, there is no motion for bond filed alleging what change in circumstances will warrant a bond hearing. We've had a bond hearing. He's not held on pretrial detention. He has a bond. The only thing that is missing is the bonds on the other two charges, I understand.
So he has a right to a bond hearing on the 2 charges where he doesn't have a bond set.
Well, for that purpose, Your Honor, I'm ready right now.
What happens if someone comes up to the jail today with enough money to bond him out on his 3 counts, and the jail says, well, he's got 4 and 5, he's got no bond, you can't bond out. So he needs a bond on those. So unless y'all want to agree to something, he needs a bond hearing.
I'm saying that I'm willing to do it right now for the 2 counts that he doesn't have it.
So you'll do it today, but you won't do it tomorrow because you have to inform the victim?
Your Honor, I thought he wanted a bond hearing on all the counts. If it's just for the 2 additional counts, I'm ready.
All right. Do you want your lawyer to file a bond motion for me to consider counts 1, 2, and 3?
Does it? Please.
I'm asking you a simple question, Mr. Sledge.
I'm kind of lost right now.
I understand that,
Because
which is why I'm taking this
1,
much
2,
time.
and 3, I have a bond or no bond. They done changed.
But you don't want me to modify those in some way?
I mean, yeah, I wouldn't mind if you modify them. I ain't gonna tell you no lie about that.
Why don't I do this? I'll set you a bond on 4 and 5. If you want to file a bond motion for me to reconsider all 5 of them, you can file a written motion, and we'll set that for a hearing where the victim, alleged victim, gets who has a right to be heard and be present for that bond hearing, that they have time to do that. Otherwise, I can just set you a bond on 4 and 5.
No, please do.
All right. Count 4 is aggravated battery causing great bodily harm. It's a first-degree felony punished by up to 30 years, and then count 5 is a second-degree felony. Ms. Rivers, do you want to be heard on bond on 4 and 5?
Your Honor, on counts 4 and 5, there is no firearm, I believe, in evidence. I believe this is all going to be based on just hearsay. So my client is asking the court to consider a reduced bond on those 2 counts.
State want to be heard on 4 and 5?
Your Honor, I would ask that the aggravated battery be set at $100,000 and the possession of weapon, $10,000 cash professional.
All right, aggravated battery count 4 is going to be $25,000 cash or professional, same conditions of as 1 through 3, which is the no contact and pretrial services. Count 5, possession of a firearm by convicted felon is going to be $15,000 cash or professional, same conditions as counts 1 through 4.
Your Honor, I would like, please, the court to order that he has no contact with the victim and witnesses in the case, because I'm aware that he's been having contacts with those.
Okay. Mr. Sledge, I've already just ordered that because I think it was previously no contact with the victim, no contact with any witness. I'll let you talk to your lawyer about that. You don't want to end up with a tampering charge because I think you're talking to the people who were involved.
Thank you.
That's it. All right. April 30th is your next court date. If you file a bond motion, I'll hear it sooner than that. All right, thank you, Mr. Sledge. We're going to take a 5-minute recess.
All rise, please.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306.
The court team, they pushed it over to your assistant, and
How
I
long
guess
do you
she's
think it's going to take?
30 minutes or more.
I think that's just kind of the 30-minute mark is kind of where we start setting them with my office instead to make sure we put it in the proper place and give it the amount of time it needs.
I'm fine, Your Honor. It's my position is going to be that if we're doing what we're supposed to do, it's just, I guess, matter of time. But I'm fine anytime you want to set it.
What are we talking about from FDLE?
Well, the additional discovery from FDLE, our expert had indicated that found some inconsistencies in the report. He wanted to look at their notes, what they did, how they came to that conclusion. There's a list of things that I had filed.
But
that he was
regarding what type
requesting.
of issue, so I understand. What type of issue, what type of expert are we talking about?
It had to do with the blood evidence, Your Honor.
Blood evidence, okay. I don't know if we're talking about, some scientific instrument that they use and what their policy, and there's so many things that FDLE does, I just want to make sure I understand what we're talking about. All right, so we want to set it for a 30-minute hearing?
Just one question, Your Honor. I have Ms. Rivers. Are you indicating that FDLE? You made a public record request with FDLE?
So Dave Anderson indicated to me that he had made a public record request, but you had indicated as well after I filed the motion that you said you had made a public record request and that there was no need to go forward with the hearing. And that was back in October of last year. And here we are at the end of February, and my client is antsy, and he wants to move forward. And so we talked about setting it. He does want to set it for a hearing.
And the only reason why I was questioning, Your Honor, is because probably you need to subpoena the FDLE people, because if they are not responding to the public record request, you may need them to come and explain, right?
Well, my understanding is that you too said you had filed it.
I'm gonna double check. I don't remember, but we can set it any time, Your Honor. I will.
I previously have had to have additional discovery before, and the court has signed an order, and I do know that but each judge is different, Your Honor.
Are you objecting to what they're seeking?
No, Your Honor, I'm not. No.
So why isn't,
It's not us. It's
why can't y'all just
FDLE.
send me an order that says FDLE needs to turn over X, Y, and Z, and I'll sign it, and if they don't send it over in the listed amount of time, then we have a hearing as to,
Before the order, Your Honor, I would like to have an opportunity to communicate with FDLE, because if we can just get it, and we can set for a hearing on the 27th, March 27th, it's fine.
that's another month.
I understand. That's when Ms. Rivers wanted to set it for.
All right. At the hearing for March 27th, what time do y'all want?
Any time, Your Honor.
March 27th at 2 o'clock.
Thank you.
Thank you, Your Honor.
Obviously, if y'all talk to FDLE and they agree to send it, or they just need an order, or whatever it is, give it to me and I'll sign it ahead of time.
Yes, sir.
Thank you, Mr. Sal.
Your Honor, this is Joseph Thompson before the court on 24 CF 2424. This is relatively early on in his case. We are going to request a continuance. I've contacted a special person to try to help us with his matter, but at this point, I'm not sure if they're going to be able to help us. So I'm just going to request a continuance at this time so I can have the opportunity to speak to other experts and see if we can get what we need.
All right. Any objections from the state? Okay, no objection from the state. Mr. Thompson, you understand? They're just trying to get together discovery and whatever potential experts you may need, it sounds like. All right, thank you. April 30th.
Your Honor, the next one is Chayton Truelove, 24 CF 60. Last time we were before the court, Mr. Truelove had made a counter offer, and the state did respond this week to that counter offer. I did convey it to him yesterday afternoon. They have a new offer.
Counter offer?
Yes, Your Honor. At this point, we're just going to go ahead and we talked about going ahead and just starting to do depositions of whoever we can. So we're going to request a continuance to 4:30. I had discussed it with Ms. Basso. Chayton Truelove. Yes.
Oh, so this case is over a year old and we haven't done depositions yet. April 30th. Say, let's make this one a priority. It just needs, these things need to get done. Anything, Mr. Truelove? All right, thank you.
Your Honor, this is Angela Watson before the court on 25 CF 19. The court had continued it till today, just to have a status to see where we were at on this particular case. I do know that I don't believe an evaluation has been done.
There's nothing wrong with me. It's just a misdemeanor. They're supposed to be able to sentence me at first appearance. It's only a bottle of soda. Why have I not got out yet?
It's not.
You told me that the last.
We've submitted a request for Dr. Zeman to come evaluate you. Dr. Zeman last week. He said he did not. So he said he did not have you on the list for that time.
You didn't. Okay. So how long it'll be till I come back again?
Your Honor, if we could put it on for 4:30,
Put it on for April 30th.
and if we get an evaluation that says something different earlier, I'll be more than happy to put it on earlier.
Okay.
All right. We'll see you back on that day, Ms. Watson. Make sure when that doctor comes to see you that you talk to him.
4 months for a soda? For a $2?
Ma'am, you're charged with burglary.
No,
Ma'am,
because I
you're
own the
charged with
store.
burglary. We'll talk to you on April 30th.
But it's a soda. I had
Okay,
keys to the
no,
store because I
if you
own
would
it. It's
stop.
not burglary.
I'm sorry? Yes, yes. Your Honor, this is Terry Young before the court on 21 CF 2775. You had indicated last time to set this matter for trial this time. I believe that Ms. Basso and I have worked out an agreement in this case. I've been speaking with Mr. Young in detail yesterday. There was a couple of things that needed to be checked. And at this point, I will need to sit down with him and go over the final terms.
Right.
And we're asking for 3-3.
Without objection.
What if it's not agreed upon on 3-3?
It is.
All right. March 3rd for a plea.
I'm going to try.
Charles Russell, Public Defender's Office. Judge, this is Holly Fowler. Case number is 24 CF 2628. I believe we have an agreement. If I could have a second.
Yes, sir.
Judge, this is going to be a plea to a lesser included misdemeanor, so there won't be a score sheet. May I approach?
Yes, sir. Can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth? Thank you, sir.
Sure.
All right, can you state your name and date of birth, please?
Holly Fowler, 12/24/73.
Okay, Ms. Fowler, you're here in 24 CF 2628, charged with aggravated assault, which is a third-degree felony punishable up to 5 years in state prison. I've been handed a plea and sentencing agreement for you to plead no contest to a lesser included offense of assault, which is a second-degree misdemeanor. Be a withholding court cost, and you have 90 days to pay your costs. Is that what you want to do today?
Yes, sir.
Did you go over this form with your attorney?
Yes, I did.
Did you understand it?
Yes, I do.
Are you satisfied with his representation?
Yes, I am, very much.
Are you under the influence of any alcohol, drugs, or
No.
controlled substances? Are you suffering from any mental health issues? Anyone promise you anything in return for this?
No, sir.
Anyone force you to do this?
No, sir.
You understand there will be a trial of any kind if you accept a plea and you're giving up your trial rights that are
Yes, sir.
on page 2 here? All right, and what is your plea, Ms. Fowler?
No contest, sir.
All right, I'll accept your no contest plea to the lesser included offense of assault, second-degree misdemeanor, withhold adjudication, 270 court costs? 622 court costs because it's assault. $100 PD fee, 90 days after release to pay money owed, or it'll go to judgment. That's what you want? All right, you have 30 days to appeal the judgment and sentence of the court. Thank you, ma'am.
Mr. Higgins. All right. Sorry, I'm just working through down to my notes on you. Judge, what I'd like to do is, I was checking into his Santa Rosa case, and I got an answer on that. What I'd like to do is pass him until March 3rd, upcoming Monday, and I'll go ahead and talk to him. I don't think the Santa Rosa case is as big an issue as I originally did. It's still pending, and they've got to capious because he's in our jail. So I think right now it's to us to resolve. Yes, sir.
What's going to happen on the 3rd?
I'm going to talk to him about it. It may be that we can go ahead and get the case tried.
Which case? He's got 2.
Well, he's got 2, Judge, and that's
really
something
old
else
and
that I'd
one's
have
new.
to talk with him and the state about, but that would give us a chance for us to figure that out. He's got one case that looks like he was arraigned on 12/26 that's set for today. That's the newer case. I'm thinking that one will get passed, and then maybe we could resolve the other.
So we're going to set the 23 case for trial?
Well, all I'm asking now is to put it on for call, Judge, so that I can.
I understand, but is it potentially going to be a trial this cycle? Just so the state knows if they're sending subpoenas?
Judge, I'm trying to keep the cases moving, that's all. So if you want to do it for plea or continuance, that's fine with me also. I just am trying not to come in and asking for a bunch of continuances.
I'm just asking what you would like me to set it for.
Give me just one second. Judge, let's make it plea or continuance. We may be able to get it resolved.
March 3rd, plea or continuance. Any objections?
No, no, Judge.
All right,
no
thank
objection.
you. March 3rd. We'll see you back on Monday.
Yes. Okay.
Mr. Berry, did you give Mr. Harrison's documents?
I am, Your Honor.
All right, who do we have?
Sir, what's your name? I'm sorry, I was making notes.
Jared
Mr. Millis, okay.
Mullis.
Sorry, we're bouncing around a little bit, Judge. Judge, I'm going to move to continue the case. You'll wind up with a different lawyer because of the nature of the charges, but I'll brief her and she'll come out and see you sometime soon.
Can I also address one thing as well? A potential witness for my case is already being represented by Miss Rivers. I just wanted to let the court know that that's...
It's on a different case, Judge.
On a different case, but...
But she is a key potential witness to my arrest. She was there
Ma'am,
when I was...
I've got it. You've pointed to yourself 4 times already. All right, so the public defender, if there's a conflict, is going to have to choose that.
I mean, I just wanted to let the court know.
I understand, so they're just going to have to make a decision on who they're going to file a motion to withdraw on, then, potentially, if there's a conflict.
Yes, sir.
All right. And then one of y'all will end up with the Regional Office of Conflict Counsel. All right, but I'm going to put it on April 30th, if y'all could file that motion relatively soon, if you believe there's a conflict.
I don't want to go into a long explanation right now, but at this point, I don't believe that there is one. But that's for Ms. Rivers to decide, not myself.
All right, thank you, Mr. Millis. We'll see you back April 30th.
Thank you.
Judge, I've been monitoring my emails while this is going on. Ms. Euler just filed motions to transfer all of Mr. Hall's cases down to the south end.
That's correct, Your Honor. It's supposed to go track with the other cases that he has in Fort Walton Beach.
Now, he does have a case set on the arraignment docket for tomorrow. Madam Clerk, if the state's filed an information, I'd like to go ahead and arraign him.
File a motion on that.
Normally, if we file a motion, Your Honor, to transfer, we have filed the information already. That's the procedure.
I'm just worried about the new one that's set for tomorrow. I'm assuming if it's on arraignment tomorrow, they've already filed an information or not.
Is it filed?
I just haven't verified it myself. That's why I'm asking the clerk, Judge.
I see an information was filed on February 3rd.
Okay. Judge, in that case, I'll enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
25 CF 141, it's a charge of battery upon a jail visitor or other detainee. All right, and then once you get me over the order, I'll sign that. All the cases will go to Fort Walton.
Okay.
Okay. Just in case that doesn't happen, I'm going to set it for April 30th, just for status purposes. But they'll all be transferred, but it has to have a court date until it is.
No, that's fine, Judge.
Out of it after today.
All right.
Okay. Judge, this is Donald Hanisch. I'm going to move for a continuance on it.
No
There's
objection.
a brand new case from January, but the other case is from May.
There's no objection.
All right. April 30th, Mr. Hanisch, we'll see you back on that date.
Okay. Judge, this is going to be a plea.
Mr. Hargraves, can you raise your right hand? Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. You're here in 24 CF 2704, charged with burglary, unoccupied structure, possession of burglary tools, possession of an unoccupied conveyance. Those are all third-degree felonies, punished about 5 years in state prison. Loitering and prowling, which is a second-degree misdemeanor, and resisting without violence, a first-degree misdemeanor. I've been handed a plea and sentencing agreement that calls for you to go on 3 years of probation for counts 1 and 3, and then time served on the other 2. Is that what you want to do today?
Yes, sir.
All right. Have you gone over this form with Mr. Williams?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
You suffer from any mental health issues?
No, sir.
Anyone pressure you to do this?
No, sir.
Anyone promise you anything in return for doing this?
Oh, no, sir.
Say again?
No, sir.
No? Okay. Do you understand there will be a trial of any kind and you're giving up your trial rights that are listed on page 2? You understand you're giving up your trial rights and there won't be a trial?
Oh, yes, yes.
All right, and those trial rights were on page 2 of the agreement you signed?
Yes, sir.
All right. And let's see here. What is your plea?
No contest. No contest.
All right, I'll accept your no contest plea on all counts. Adjudication of guilt on all 5 counts, but on counts 1 through 3, 3 years probation, restitution of $1,850. Do we know who that's to?
Kemp Brothers Construction.
Kemp Brothers Construction. Court costs of $515. No trespassing. Don't return back to 2722 Hugo Lane in Crestview. You're to maintain gainful employment, or if not gainfully employed, complete at least 2 job applications per week. And on 4 and 5, it's just the adjudication and time served.
Thank you, Judge.
All right, so Mr. Hargraves, this is a guideline sentence, correct?
Yes, Judge.
Meet with probation, then your step over be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court.
Sir. All right, good luck, Mr. Hargrave.
Your Honor, can I get that address? 2722.
Hugo, Hugo, Hotel Umbrella Golf.
Based on,
Say again?
supervision fees away based on.
Yes.
And Judge, I'll move to waive supervision fees on all public defender clients.
Just if you put it in there, I'll remember to say it, otherwise sometimes I forget, and then Mr. Berry has to yell at us.
Judge, I'm going to move to continue this. One of the cases is
They're both
relatively
very
new.
new cases. State,
I believe so. This is Robert
Harrison.
Clyde. That's yours.
No objection.
Or, right?
All right, April 30th, we'll come back for your next pretrial conference. Mr. Harrison, someone will come out and see you to talk to you about it.
Okay, Mr. Harrison.
That's mine.
What do we have?
Judge, this is Randall Hartley. Judge, he's got a misdemeanor. Right now, we're not going to be in a position to accept the offer. We'd be going to trial, but
On the misdemeanor?
no, on the felony. He's also got a
Oh, I see.
VOP case. The battery involves an allegation that his nose touched the officer's chin. That's the source of the bat Leo. I think it's relatively new, but I have asked the state to take a look at it. I think they may need time to talk with
Yeah, it's from
somebody.
December.
Excuse me?
It's from December.
That's correct. I mean, on the violation of probation, one of the terms was no drinking. Facts also include a violation based on his drinking, and he was originally given a downward departure. So that basically is why the state's offer is now a guideline due
Which is what?
26.7 months.
Judge, what I've inquired of the state is that if we can work out a plea to a misdemeanor on the new case, he would go ahead and accept the 26 to 27 months. That's what we're talking about. So if you want to set it for 3-3 to see if we can get that done, we're good with that.
3-3 for a possible plea, otherwise continue.
Thank you, Judge.
Can we sneak in Mr. Harrison?
Try to, yes, sir.
He's not represented, I think. It's a. Y'all have Harrison on your. He was supposed to be here on Monday. Kenneth Harrison?
I believe.
It was a situation where there was a VOP, and what was announced at his last court date was to be continued to today. He was to get documentation of probation. Mr. Berry has seen that. What the state said at that point was, you'll probably just dismiss it as far as his VOP, and non-monetary is going to go to collections. I'm sorry. Since all the non-monetary are completed, the monetary would go to collections.
So he's shown proof of his non-monetary
Yes, there's
probation
substance abuse
requirements.
treatment.
Substance abuse evaluation and treatment.
Then that is correct, and we can dismiss the VOP.
Okay. Do you have that? All right. All right, so your VOP is dismissed. Your your monetary is going to go to collection, so you should set something up to pay that still. Otherwise, they're going to try and collect it from you. All right. Any questions, Mr. Harrison? So he's officially off probation.
That is correct.
All right, it's dismissed. All right, thank you, Mr. Harrison. Sorry for the wait. I just wanted to check all that stuff out. So, all right.
Judge, Ms. Hegland is present before the court. Let me find this. Oh, I guess you have it.
It's mine.
Okay. Well, no, what I mean is that you have the plea agreement.
Oh.
I had Ms. Hegland evaluated. The evaluator's opinion is that she is competent, and so we're ready to proceed with entry of the plea. The court will recall we were kind of going back and forth on the plea when she was in court last time.
Who was the evaluation by?
Dr. Zeman.
All right, Ms. Hegland, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Hopefully, to the best of my knowledge, yes.
Not hopefully. It's a yes or no.
What we went over yesterday?
Yes.
I'm asking
Yes.
if you're going to tell me the truth.
Of course.
What is your name and date of birth?
Brooklyn Hegland, 11/09/1998.
Okay. And Ms. Hegland, you're here in 24 CF 2821, where you're currently charged with possession of a controlled substance in violation of a domestic violence injunction. Do you understand that?
Yes, you.
All right.
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plead no contest to both of those. In return, to be adjudication of guilt and 3 years probation, substance abuse evaluation and treatment, random urinalysis, no trespassing at an address in Crestview. I'll get through all that, and abide by the injunction. Is that what you want to do? Is that what you want to do?
That is what I would like to do.
Okay. Have you gone over this form with Mr. Williams?
You have.
And did you understand it? Correct. All right. And did you sign it?
Indeed.
And are you satisfied with Mr. Williams' representation in your case?
Very much so this time.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Do you suffer from any mental health issues or concerns? Not at the moment. What does
I'm
that
very
mean?
nervous about the trauma in the street, man.
Okay. What does that mean?
Danger's out there.
Okay. Is the jail less dangerous?
The jail is toxic.
Okay. So this will allow you to get out, right?
What? Sorry.
All right. So, again, do you have any prior mental health diagnoses?
No, because I've not gone to the hospital about it.
Has anyone forced, pressured, or threatened you in any way to get you to enter this plea?
No.
Has anyone promised you anything in return for your plea? You understand that if you enter this plea, there won't be a trial of any kind. You understand that you're giving up your trial rights, which are on the agreement that you signed.
Mother, I brought them clothes.
Okay, that's not what I asked you,
And I
ma'am.
had a piece of meth on me.
Say again? Okay, but focus on my questions. Ma'am, I have to ask you these questions just like I ask everyone else. Do you understand that you're giving up your rights to a trial, which are in this agreement?
Yes.
Okay. Do you understand you're waiving any potential defenses that you may have?
Yes.
Okay. you understand you're going to be on probation for 3 years and you have to report to them?
Yes.
Okay. All right, based on the fact that there's been an evaluation, according to Mr. Williams, where Dr. Siemens found her competent and her answers to the questions today, what's your plea, ma'am?
No contest.
No contest.
All right, I'll accept your no contest plea. Adjudicate you guilty on both charges. 3 years probation, waive cost of supervision, $615 in court cost, substance abuse evaluation and any treatment, random urinalysis for the detection of any drugs or controlled substances that you're not prescribed, no trespassing at 3141 Winstead, is it Cove?
Please do not speak on
My understanding.
Okay, you can't go back to that house, ma'am. Abide by the injunction in 22 DR 2673, $150 public defender fee. That's for count 1. Count 2, because it's a misdemeanor, is an adjudication, 1 year probation concurrent. All right, Ms. Hegland, you're going to have to go back and talk to probation real quick. Then you'll be fingerprinted. You have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
What is your name, Judge?
It's Oberleeson. He's in a different division now.
Thank you, Ms. Hegland. Go talk to probation.
Okay. I'm ready to go. All right. There's two. All right, Judge, what I had indicated to do and decided to do was to set him for March 3rd. He was going to consider his options. He's just handed me a couple of papers. I haven't had well, one of them is a motion that he wants me to file that I am not, that it's a C4 motion, but he's not accepting all the facts. So I will talk with him further about it, but let's put him on for 3-3.
All right, Mr. Henderson, we'll see you on Monday, March 3rd. We can talk about if you're ready to plea on that day, or do you want to file the motion or go to trial?
Well,
Okay.
Your Honor, 1 second. If he needs to decide on Monday, if he needs to go to trial, we won't have enough time to issue subpoenas. So if we need to set it for
Well, if
trial.
it's going to go to trial, it'll be the next cycle.
Oh, next time. Okay, sorry. I thought you meant.
I'm ready to go to trial right now. That's what I'm trying to do.
All right. So then we'll set you for trial.
Okay.
And can I read this too, or it don't
No,
it
sir.
don't really matter to? Said I like dog man. I just hand him. Oh no, he said no.
I said, we're here to set a case for trial or continue it or enter a plea, but I'm not going to listen to letters right now. If it's something that's important, tell it to your lawyer. He can convey what needs to be conveyed.
Right. Well, if that happens, then he'll grant a motion for judgment of acquittal that will come at the close of the state's evidence.
So I get to go to jury trial, right?
Yes.
And that's the trial will be 24 CF 788. The other one's a VOP. Okay. All right. Your name, ma'am? Your name? Hinson?
Judge, this is going to be a plea.
Okay.
Ms. Henson, what they're going to do is on that battery, they're going to withhold and put you on probation for a year concurrent. Okay, it'll still be a total of 2 years. Okay.
Ms. Hinson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your name and date of birth, please?
Isis Henson, 11/17/2004.
All right, you're here in 24 CF 2042. You're currently charged with aggravated assault, which is a third-degree felony punished by up to 5 years in prison, and battery, which is a misdemeanor punished by up to a year in county jail. Do you understand that? All right, I've been given a plea and sentencing agreement that calls for you to put on 2 years probation, no contact, batter's intervention, and mental health evaluation and treatment. Is that what you want to do today? Okay. Have you gone over this agreement with Mr. Williams, your attorney, and did you understand it? Did you sign it? Are you satisfied with Mr. Williams' advice and representation? Are you under the influence of any alcohol, drugs, or controlled substances? Do you suffer from any mental health issues? Has anyone promised you anything in return for your plea? Has anyone forced, pressured, or threatened you in order to enter this plea? No, sir. Do you understand there won't be a trial of any kind if you enter a plea? You understand you're giving up all the trial rights, which are on page 1 and continued on page 2 on your agreement? And you understand you're waiving any potential defenses that you may have? All right. And what is your plea?
No contest.
No contest.
All right, Ms. Henson, I'll accept your no contest plea as to both counts. As freely voluntarily knowingly given. Count 1, adjudication will be withheld, 2 years probation, $967 in court costs, $150 PD fee, no contact with the victim. Do we have a name?
Judge, it's going to be Juwan Rafiq Borden. I can spell that JUWANRAFIQ
Stay away from Mr. Borden. Batter's Intervention Program, which is a 26-week course. Mental health evaluation and any recommended treatment must be successfully done. And on count 2, it's going to be a withhold, 1-year probation, all concurrent with count 1. All right. And this is a guideline sentence.
I believe so, Judge.
Yes. All right. Ms. Henson, you're going to go over and talk to probation real quick, then you'll, oh, it's a battery, so I'll still need fingerprints. Then be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court if you'd like. All right, thank you.
Judge, my investigator was able to locate some documentary evidence that we've ordered from the state of Tennessee. We're hoping to have it back. It's being sent to us by mail. What we can do is leave it on for the 3rd, see if we have it back, and see if that either changes things or gets us in a position where we can go to trial. It has to do with an alternative suspect for the drugs that were found in the vehicle.
Is there a current plea offer in the case?
Well, I think it's 25-year min-man.
It's a trafficking case, Judge.
Trafficking,
This is
the one we had the motion to suppress.
I know the case. I just didn't realize it was
Yeah.
that kind of amount.
It's a minimum mandatory. And also, Your Honor, we have instructed law enforcement, we have sent the additional drugs to FDLE because the methamphetamines with which he's charged was not tested. So the state would be fine to continue it one cycle for FDLE to test the second quantity of drugs.
I'm not asking to continue the case, Judge, until I find out whether or not I need to, whether or not I have that
When are you gonna
information.
find that out?
I'm hoping that it will come this week, in which case I can tell everybody I've got it on Monday. If I don't have it on Monday, then what I'll do is I'll advise the court that I don't have it.
on Monday?
I'll see if it changes the state's position at all. And at that point, I guess the prosecutor would be moving for a continuance.
Are you saying that
Because
you're
you're
ready for
wanting to-
trial? If you're ready for trial, we can go on trial on the charge that we already have. I'm ready.
I don't want to go to trial without this evidence, is what I'm saying. So I want to see if we have it, and then I want to see if you feel like you...
But we can't go to trial this cycle if you're telling me now you're not ready.
All right, then, Judge, I don't have the evidence in front of
Yeah,
me,
I'm
so
not
I
trying to be
can't say...
critical, Mr. Williams, but the state has to have so many days before they can send out subpoenas, otherwise they won't be served.
I'm just trying to move it along, Judge, that's all.
Well, so plea or continuance for Monday?
Plea or continuance is fine then.
March 3rd, plea or continue. One other thing really quickly, Mr. Williams, did y'all want me to do a written opinion on the suppression motion for
Yes,
appellate
sir.
purposes? or I'm sorry, written order.
Yes, sir, I think that's going to be.
I will put that on my list.
Thank you, Judge.
I mean, I tried to spell it all out on the record the other day, but I'll certainly do a written order.
Yes, sir.
Just want to make sure that's what you wanted me to do. All right, thank you, Mr. Horn. We'll see you back on Monday.
All right, sir. Not today, sir, but I'll, if it gets continued, well, I may file it anyway, and we'll set it if it gets continued. Judge, this is Gary Hudson.
Hold on, Your Honor.
This is yours.
Yes, it is.
What I asked about was time served.
Can we leave them on for Monday and I'll have a response to you?
That'll be fine. Thank you, Judge.
March 3rd, clear, continue.
So we'll see you on Monday. Judge, we're still trying to work this one out. I'd like to leave it on for docket day for a possible plea. We're trying to get one of the charges removed.
Mr. Williams, who's this?
David Wesley Johnson. This is the one that that contacted us and said that it wasn't false imprisonment.
And you're asking for a continuance?
No, I'm asking to leave it on for the 3rd, so if that goes away, I think we can resolve it with a plea. If that'll be enough time for you to look into that.
To do what? To dismiss the...
Yeah, potentially getting rid of the false imprisonment charge.
I'm not inclined to do that based on the evidence in the case.
Okay, even if the victim... Let's do this then, Judge. I'll continue it, and I'll take the victim's deposition.
April 30th. We'll see you back on that day, Mr. Johnson.
Okay, that way I'll get her under oath on it. Judge, this is Charles Wesley Kemp. I checked. It looks like our reciprocal discovery went out, I'm going to say about a month ago or more. I'm going to announce ready for trial.
Sorry, Judge. I'm pulling this. This is Charles Kemp.
Yes.
Trafficking? No?
No, it's...
criminal mischief resisting.
So you said you sent something. I didn't understand. Did you say something?
Yeah, we filed a reciprocal discovery, and we also sent, I think, an email that the mother had sent us.
Okay, I have to review
saying that the property is his.
I will, when did you share, Mr. Williams? I would like to have an opportunity to review that.
Discovery, I'm showing February 3rd, so over 3 weeks ago. But, oh, that says acceptance letter from Phoenix House.
Oh, yeah, that
now, there's
I
an
saw.
earlier, there's one with his mother.
Phoenix House, I saw that, Your Honor. I thought it was something else.
Oh, here's one on January 6th. Letter from Helen Sue Reeves.
That would be the one, Judge.
Okay, it was January 6th.
Okay, oh, here. No, that's the defendant. So I guess my question, because they shared the Phoenix House acceptance, does he want to plead to Phoenix House? Because I can consider that.
I will go out and talk with him again about that and see if he wants to do that. We can set him for Monday if the court will leave negotiations open for Monday. All right, Mr. Kemp, I'll come out and I'll talk to you. They're offering to send you to Phoenix House, and we'll see if that's what you want to do. If not, we'll go to trial.
I won't plead no contest or guilty.
Okay.
It's my house.
So I don't think it's fairly likely, his position.
I'll put it down for plea trial for Monday.
Thank you,
So
Judge.
if you don't take the plea, we'll set it for trial.
Thank you, Judge.
All right. Thank
Okay.
you, Mr. Kemp. We'll see you Monday.
Judge, this is the first time up. I'm going to move to continue.
April 30th for Mr. Lambert.
No objection.
We'll see you back on April 30th for your next pretrial date. Thank you, sir.
Judge, this is Harvey Howell Langley, the fourth. I'm going to ask to set it for March 3rd without subpoenas, talk with the state and see if we can do anything to get it resolved.
These are two new cases. All right, March 3rd for plea or continuance.
Thank you, Judge.
All right, we'll see you on Monday, Mr. Langley.
Yes, sir. Judge, the state has I sent over by email a motion. The state has a paper motion. I like theirs better.
Yeah, approach is the order, it's not the motion.
Oh, it's order, not motion, order.
Okay. Okay, so this is an agreed upon order to compel him to give the DNA swabs?
Yes, sir, which I understand I had the same reaction, that we
He's the
shouldn't
one
need
that
to
wants the
compel it.
DNA
He's willing to
testing,
do
right?
it voluntarily, so, but,
The issue is that the sheriff's department needs an order before they can actually go to see the defendant, so I wasn't trying to be difficult.
All right, so you understand, Mr. Lewis, this will have them come out and take your cheek swab for DNA purposes?
Yes, sir.
That's what you want, right?
Yes, sir.
Okay. So I've signed that order, I'm giving it to the clerk.
Thank you, Your Honor.
thank you, Judge.
I'm assuming we want to continue this to the
Yes, sir.
4:30 date?
Yes, sir.
All right, Mr. Lewis, we'll see you back on April 30th. Hopefully, they're all ready to go by then. Thank you.
And Judge, disregard the one I sent by email.
Okay. I haven't seen it yet.
Judge, this is Jeffrey Long. I've talked with the state about it. If Mr. Long, it looks like it's going to be able to be null-prost. He can handle that remaining issue. We're thinking and hoping for Monday. He's got to get somebody else to make the payment for him.
Or I could,
Is it not possible for us to order the $100 paid through the clerk if we order the victim very specific, give specific instructions, and then it's payable through the clerk?
The idea is he's going to pay, there's $100 restitution still owed. He's going to pay the $100 and it's going to be dismissed. He's in jail, so he can't go over there and give her the $100. He's got a brother that can do it for him.
I mean, I would prefer that, yeah, for some, that direct contact not be made, but with the
By
defendant.
him.
Yes.
So what are we doing today?
You want to leave it on for Monday? I can call the victim and make sure that she's expecting that. I can, with your permission, I'll state with the defendant's brother.
Sure.
And we'll see if we can confirm that's been done, I guess, Monday. I'm kind of a tight timeline, but we can.
I don't want to continue him out, although if we get there Monday.
I 100% agree with that.
If we get there Monday and it hadn't been done yet, then, we can set him for a miscellaneous date or something like that. And of course, once the state files an all process, the jail will release him.
Speak freely. Yes. I just, I have money, but I can't have a direct contact with the victim. I have no problem with that. You know what I mean? I just need to make a phone call besides the jail phone, if that's all possible.
Besides the jail phone?
Or, where I have inside of our unit, where I had to go through a tablet to call. If I could, I could probably take care of it pretty easily.
That's fine. I think all they're saying is if it's taken care of and they get proof that it's been taken care of, they'll file a dismissal of the case and you'll be released. Otherwise, we'll come back Monday to make sure that's happened. I can't tell them to dismiss it, and they won't dismiss it until the $100 is paid. But they can't say, we'll dismiss it and I'll order you to pay the $100, because once they dismiss it, I don't have jurisdiction to tell you to do anything.
Right.
So, all right. So, get it done. Just make sure you don't have any contact with whomever you're not supposed to have contact.
Thank you, sir.
All right.
Otherwise, we'll see you Monday. I hope to not see you, because that means it's been done and they probably released you at that point. All right. Thank you, sir.
Judge, this is Diana Malone. I filed a notice of intent to rely on the insanity defense and filed a reciprocal with Dr. Zeman's report. Dr. Zeman would be the expert on it. I don't know that she added his name or just sent the report. So if you need me to file a amended reciprocal specifically stating Stephen Zeman as the expert, his name's on the report, though. You have his name.
I don't need that.
So we're going to have a trial on where her defense is going to be insanity. Now, the only issue is I've got to confirm with Zeman when he's available, obviously, since he's my expert. So we can set it on for the 3rd, and I'll have Sarah call him and see if we can nail him down for either the 1st or the 2nd week.
No, Your Honor, I wouldn't be ready for that because the victim lives out of state and I would have to arrange for travel. I wasn't ready for this to be set for trial.
This is a pretrial conference. This is when we set things for trial.
No, I understand. It's just that I haven't even communicated with her about it because I wasn't sure we're going to be setting it.
I'm going to set it for trial. I mean, she's sitting in jail. It's time. What's the point of the pretrial conference if we don't know if we're ready to set things for trial or not?
That's fine, Your Honor.
I mean, if there's an issue, then you can bring that up, and I'll entertain a motion to continue because the victim can't be present. But until we know that, let's just set it. All right, we'll see you back on Monday, March 3rd. Hopefully, Ms. Leone can hear back if she knows the victim can be available.
Well, not only this, Your Honor, I may need to ask my own expert opinion on the defense because it's their expert. I haven't even communicated with him. I haven't had the chance to depose
You
him.
filed this notice of intent to rely on this insanity defense January 2nd.
I understand, Your Honor. I just need...
It's like 6 or 7 weeks ago.
I realize that.
So, but what you have to realize, when someone's sitting in jail, they can't wait 7 weeks to see if you're going to try to get a new expert and then continue it another 2 months. I'm trying to push these cases through, but if things are getting filed, you know, you've heard me enough get on the defense people when they don't do things until the day before pretrial, but this is filed 7 weeks ago and nothing's been done on the state side. If you're going to get an expert, you got to get an expert. March 3rd.
All right, Judge. All right, ma'am. Okay. Judge, I'm going to move to continue the case. I'm trying to get her into an alternative program.
Objections?
I believe there are 2 cases.
I've only got 1. Oh, no, there's 2. Oh, there it is. There's 24 CF 1446, and there's 24 CF 2512.
And there's no objection to a continuance. The state would be going to trial first on the more recent arrest case, 24 CF 2512.
Okay. All right. April 30th, we'll see you back on that day, Ms. Lawson. Sounds like they're trying to set up some sort of alternative sentencing program for you.
Judge, this is Tyler Ray Mills. I've gone over the offer with the defendant. I've gone over the issues in the case. He would like to go to trial.
Date, ready for trial?
Just one moment, Judge. Tyler Mills.
This is the fleeing and attempting to elude at PetSmart.
Judge, the state would ask for a continuance. The arrest was in October of 24, and we have gone actually around several times with the defense attorney regarding a subpoena for medical blood that we have pending to the, I believe it's to North Okaloosa Medical Center. And one of the reasons why it took some time is we actually did have some discourse about what the language to be used in that.
We did, Judge. We went back and forth on it, and I think the last revision I advised that I found the language acceptable.
What's the medical blood for?
So this is a fleeing and eluding and leaving the scene of an accident. The theory, law enforcement theory, is that he was also impaired, driving while impaired, and so we're seeking the medical blood from the hospital in the event that it shows a chemical substance. We would file an additional count of DUI.
Mr. Williams, you objecting to the continuance?
Judge, for the record, I'll object, but we have continued the case before ourselves, I believe.
Has the subpoena gone out yet?
I believe so. I know that the 10-day letter had gone out and that deadline had passed. I believe it was early February that we were going to issue the subpoena to North Okaloosa.
I filed an objection, and then we eventually agreed on the language, and so she's in a position that she can send that out. And I've explained it to the client.
You basically withdrawn your objection to it.
I don't have an objection to the language that we ultimately came up with. The original language was bad, but...
So you've withdrawn your objection based on the amendment to the...
That's correct, Judge.
And it's been previously continued by the defendant?
I believe it has, Judge. Might want to double check me on that. I'm working off a list instead of my actual file. Yeah, it looks like we continued.
Well, it went to January 6th, and on January 6th is when it got continued.
Oh, okay.
All right. April 30th, but I would suggest that when that stuff comes back in, y'all get ready to, if you need to depose someone, or if there's any experts going to be involved, we go pretty quickly.
Yes, sir.
See you back on April 30th, Mr. Mills.
Mr. Moore. Jeffrey Moore.
Judge, I'm still awaiting the report from the veterinarian. It's an animal cruelty case. It's the first time up. I'm going to move to continuance.
I'm sorry, just to clarify, you're waiting for discovery from the state regarding?
Right. The allegations are that the seriousness of the injury and.
Yeah, I'm familiar with that. I just wanted to make sure if you're asking for me for something
Yes.
specific, I want to make sure.
Yeah, the DVM's report stating the injuries that were determined and the seriousness of the injuries. Now, last time we took the deposition, and the deposition, we got more information, but I want to have the report before I take the deposition. Now, he has...
Did you take a deposition in this case?
No. We'd had a previous similar case, Judge.
So you're asking for a continuance?
Yes.
You're asking for?
Yes.
There's no objection. This was a December arrest.
December case. All right, April 30th.
Sir, I'm sorry, he's asking me instead, ma'am, what is your current offer?
For the two violations of probation and the new law, it's global guidelines, 23.25 months, DOC.
So you understand that state prison? No, that is the, on all the cases. I tell you what, Judge, leave it on for the 3rd. I'll go out and see him and sit down with him and explain things a little bit better this weekend.
All right.
Your case. So you'll be coming back in on Monday. I'll explain, go over the guidelines with you, and explain to you again why we're wanting the report from the vet. Okay? If you want to, sir, you can plead anytime you want to, but that doesn't change what the offer is. Okay?
Well, could you give them the...
This is, all right. What is it that you're offering to plead to, and what sentence are you asking for?
I mean, I'll take Your Honor, may I say
I
something?
don't negotiate, Mr.
Yeah,
Okay,
he's
well-
not,
well, if
he's
I
not
get-
part of the
okay, well,
negotiation.
if you can get their attention, whenever I have first took probation, it was either pay for fines or take with probation withheld
You
adjudication.
have a new case.
I know. I understand that. So whenever these charges came in, okay, you know, I don't understand how like the point system work or anything like that. All I know is that, you know, I don't necessarily squad to go to prison, but I was hoping maybe we can do like a suspended sentence because I have, my daddy just got out of the hospital. I got
All
a
right,
baby on the way.
What he's offered to do is come and talk to you and can bring you back on Monday.
I'm going to go ahead and I'm going to give this to you, okay? It's a copy of the plea offer and a copy of your guidelines. This is your actual guideline score, and this is the lowest permissible sentence. And when I come out this weekend and talk to you, it's probably going to be Sunday, we'll go over that in greater detail, okay?
So, I mean, we'll be able to take care of everything by Monday or no? Because if not, we might as well just push to April 30th.
You decide whether or not you plea.
I'm not taking any type of time like this.
Okay, all right. Then do you want me to go ahead and just set it out for April?
Yeah.
Like I had originally asked?
Yes.
All right, thank you.
April 30th.
Thank you, Judge.
Thank you, Mr. Moore.
William Moore. Judge, this is William Cockrell Moore. At our last court appearance, he indicated he was going to be hiring private counsel.
How you doing, sir?
Good. Have you hired private counsel, sir?
I'm in the process of calling around. I talked to Larissa Dudley and got a price from her, and I'm also Brad Stewart. I'm also talking to him.
Your Honor, the state is ready for trial.
All right, Mr. Moore, what do you want to do today? Because every time you ask for it to be delayed, it's usually 2 more months.
I would like a little more time to see if I can.
Judge, he was, looks like he was arraigned back on October 31st. So it was the end of the of October case.
You want it to continue to the end of April?
Over the state objection.
Let me tell you, Mr. Moore, you got to make a decision on a lawyer pretty quick, because you keep telling Mr. Williams by saying I'm hiring someone else, basically don't go do the work. And then if you get to the point where you don't hire someone else, now you're going to tell Mr. Williams, go do the work, and he's going to have been sitting around for 2 to 4 months because you're telling him not to do that. And then you're the one that's sitting in jail while the case is pending. I'm just making sure you understand all those things. All right, we'll see you back April 30th.
All right.
All right, this is Shane Morrow?
Yes, sir.
Okay, Mr. Morrow, you're here in 21 CF 2674 and 21 CF 2998. Did you have a concern about counsel?
I did.
Was that just because of who prior counsel was, but it's not him anymore?
Well, I believe that I had a conflict with him. He did just advise me a little bit ago that I think Lisa Rivers was going to be taking over the case.
Oh, is that, he'll be on the other side of the split then?
Yes, that's correct,
So
Judge.
it'll be Miss Rivers. I don't have any control over who the public defender assigns to your case. I just basically assign the public defender or not.
Yes, sir.
So if it's Miss Rivers, are you going to have those concerns?
Actually, I was reconsidering that. I don't think I will. As far as any concerns with her, I'm not familiar with her or anything, so.
I just want to make sure. Obviously, that's one of the reasons why we're here, right?
Yes, sir.
Okay. So what do we want to do with the case then?
Judge, what I'm going to suggest is we go ahead and continue it. We're basically going over a trial from before, the evidence for a trial from before. So it's going to take a little bit of time. I'm not finished reviewing all the discovery and the depots and all.
I have one quick question. My last court date, we had discussed that I was going to withdraw my plea. I don't know if that actually happened because of
It did.
everything. Okay, it did.
Yeah, it
Okay,
did.
yes,
Your
sir.
plea's been withdrawn.
I think the previous court has done that already.
Yeah, Judge Gonteric did it.
Yes.
Okay. Yes, sir.
And to be honest, I skimmed through your DCA opinion.
Yes, sir.
So I'm familiar with it, and I think Judge Gonteric already handled everything he was supposed to do as far as the remand and the instructions that were in that. So we're kind of at a start-over position at this point.
Yes, sir.
All right. Whose case is this for the state? Ms. Basso? Any objection to the continuance?
No objection, Your Honor.
I mean, I know it's an old case, but it's back on a reversal, so.
Not a problem, Judge.
All right.
We also have the new charges in Leon County.
Okay. How new are those?
While he was in prison, he managed to
Okay.
chat with another child.
All right. Well, I don't.
Unfamiliar with that.
All right, April 30th, Mr. Moore, we'll see you back then. Obviously, if you have any continued concern or future concern, just make sure you make the court aware of those things.
Yes, sir.
All right, thank you.
Thank you.
And Your Honor, Mr. Moore was my last case. May I have a quick question?
Yes. Sorry. It's one of those things, if I reach past the microphone, then you can't hear it as well, and that's what I did. So yes, of course.
Pretrial detention, 12:30 tomorrow.
Yes.
Okay.
Did you just have one?
Yes, sir. I have the Vogel case tomorrow.
All right, Mr. Morton's here in 24 CF 2336. All right, Mr. Morton, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your name and date of birth?
Tommy Ray Morton, 8681.
All right. And Mr. Morton, you're here in 24 CF 2336, charged with possession of more than 20 grams of marijuana, third-degree felony. Do you understand that?
Yes.
All right, you can put your hand out. I've been handed a plea and sentencing agreement that calls for you to get 2 years of probation with some terms. Is that what you want to do?
Yeah.
Okay. Did you go over this plea and sentencing agreement with Mr. Williams?
Yes.
Did you understand it?
Yeah.
Did you sign it?
Mm-hmm.
Are you satisfied with Mr. Williams' representation?
Yes.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Or do you suffer from any mental health issues or concerns?
No.
Did anyone force or pressure you to do this?
No.
Anyone promise you anything in return for doing this?
No.
You understand if you accept this plea that there won't be a trial and you're giving up your trial rights that are listed here on page 1?
Yeah.
And what is your plea, Mr. Morton, to the possession of marijuana?
No contest.
Okay. I'm going to accept your no contest as to the third-degree felony, marijuana. It's adjudication of guilt. That makes you a convicted felon. Do you understand that?
Mm-hmm.
Okay. 2 years probation, $615 court costs, $150 PD fee, waive cost of supervision, 24 hours of community service work, maintain gainful employment, or do 2 job applications per week. You understand all that?
Yes, sir.
All right. All right, so step over and see probation. You need to be fingerprinted, and then you've got 30 days to appeal the judgment and sentence of the court. This is a guideline sentence. Thank you, Mr. Morton. Talk to probation first.
It's yours.
Judge, this is the second time up.
Who's this?
This is Jonathan Joshua Murphy.
24 CF 2181.
Yes, sir. I'm going to move to continue the case. We have received some positive letters. I believe we provide them to the state, but they're still seeking a state presence on it. So we're going to have to come up with something
What
else.
else are we going to be doing over the next couple of months?
Judge, I'm going to be getting it ready in case it has to go to trial.
Objections?
May we approach briefly?
Yes. 2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
All right, April 30th, Mr. Murphy, someone's going to come out and speak with you, then we'll hear back from you on the 30th.
Judge, this is going to be a plea. Sadly, this is going to be one. Get there. Get his signature on. Basically, the state accepted our counteroffer this morning, but there's no pass-through in the conference room for him to sign. Get your signature right there, sir. Okay. You mind if I date it for you, sir?
I'll give it to you.
It's news to me. Hang on. Judge, I'm going to go ahead and give you the plea agreement. See if everybody's-
Good idea.
The
Mr.
one
Williams.
that I had redacted and corrected based on the agreement.
Yeah.
Is it a guideline sentence?
No, it's below, it's a downward departure by a few months.
All right, Mr. Myers, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, you're here in 24 CF 663. You're currently charged with 4 counts of aggravated assault. Those are all third-degree felonies. Shooting at an occupied vehicle, second-degree felony, punished by up to 15 years. Fleeing or attempting to elude, third-degree felony. And possession of a firearm by a convicted felon, second-degree felony. Do you understand that that's what you're currently charged with?
You found it? Oh, okay.
All right, I've been handed a plea and sentencing agreement that would have you plead no contest to count 6 and 7, so that's the fleeing or attempting to elude and possession of a firearm by a convicted felon for 12.1 months, Department of Corrections. Is that what you want to do today? All right, and all the other counts would be dismissed.
Yes.
All right, did you go over this agreement with Mr. Williams, your attorney? Did you understand it? Did you sign it? Are you satisfied with his work and representation for you? Are you currently under the influence of any alcohol, drugs, controlled substances? Do you suffer from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to do this? Has anyone promised you anything in return for your plea? Do you understand that if you enter a plea, there won't be a trial and you give up all your trial rights, which are on page 2 of the agreement you signed? You understand you're waiving any potential defenses that you may have? In State's Agreement's 12.1, just to make sure it's clear then, the possession of a firearm by a convicted felon was that a constructive possession?
Possession, Your Honor.
Even though you've been charged with shooting? All right, State's Agreement, right? I know
What
you're
did he plead to?
you're dismissing the 4 counts of aggravated assault and a shooting in an occupied vehicle.
Yeah, yes, so it's constructive possession.
All right. What is your plea, Mr. Myers?
No contest.
All right. Your no contest plea that negotiated 12.1 months DOC. It's going to be adjudication on counts 6 and 7. State have an announcement on counts 1, 2, 3, 4, and 5.
State dismisses those counts.
Court costs. $548 in court costs, $150 PD fee, credit for time served. It's a downward departure based on an uncoerced plea bargain. The
Yes, Your Honor.
state's agreed to do less than the guidelines show.
Yes.
Has the state communicated with the alleged victims in those cases that have been, or those counts that have been dismissed?
Yes.
Okay,
They were dismissed because of the victim statements. They didn't want to press charges.
okay. All right, do you want me to just put the monetary to collection since it's a prison sentence, Mr. Williams?
Yes, Your Honor.
Okay. Monetary to collections. All right, Mr. Myers, I just need you to get fingerprinted, and you have 30 days to appeal the judgment and sentence.
Good luck, sir. Thank you. Judge, this is Marshall Nance. This is the plea.
24 CF 2766. Mr. Nance, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, your name and date of birth, please. Mr. Nance, you're here in 24 CF 2766 with a charge of theft from a construction site, which is a third-degree felony. I've been handed a plea and sentencing agreement that would call for you to plea as charged, be adjudicated, be a convicted felon because of this, and 180 days in county jail. Is that what your understanding is? Is that what you want to do? Did you go over this form with your lawyer? Did you understand it? Did you sign it? Are you satisfied with his advice and representation? Are you under the influence of any alcohol, drugs, or controlled substances? Just wait till I finish and then respond. You're saying things very softly, so it's not being picked up by the microphone. So if you do it when I'm talking, it's definitely not going to get picked up. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Or do you suffer from any mental health issues? Has anyone forced, pressured, or threatened you in any way to get you to enter this plea? Has anyone promised you anything in return for your plea? Do you understand that by entering a plea there won't be a trial of any kind and you're giving up your trial rights that are on page 1 and 2 of your agreement? Do you understand you're waiving any potential defenses that you may have? All right. And what is your plea to the count of theft from a construction site, Mr. Nance?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 180 days county jail, credit for time served, restitution to Jeffrey King, reserve jurisdiction on the amount for a period of 90 days. So if y'all don't agree to the amount, you can have a hearing. $515 in court costs, $150 PD fee, no trespassing at 609 East Chestnut Avenue, Crestview. State's agreement.
Yes, Your Honor.
All right, and guideline sentence.
Yes, Your Honor.
All right, Mr. Nance, step over and be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
Judge, we've been negotiating back and forth, including further
Who's this?
negotiations today.
Who's this?
Oh, this is Tyler James Nichols. Judge.
I know we hear court security say out the name, but it has to be on the record, so I will make sure someone says it. All right, go
Yes,
ahead.
sir. I've gone over it with him. I think he needs to think it over. If we can set it for call on 3/3 for plea or continuance.
Objections to that?
No objection.
All right, we'll see you back on Monday, Mr. Nichols.
Sir.
March 3rd.
Okay.
All right, this is Mr. Nitsky.
Yes, sir.
24 CF 2939.
Judge, this is one where I tried to see him in the back to relay an offer, and unfortunately, they weren't brought over in time.
Okay.
And have just a moment. Judge, it looks like we have a negotiated plea here for 60 days county jail. Are you familiar with the rights that are on here?
Yes, sir.
I mean, it's the same boilerplate form. Okay. There you go. All right, let me get your signature here. Now, the court costs us $40, $115 because it's a drug case, okay? $150 fees, but you'll have 90 days to pay it or to get on a payment plan with the clerk. I made it 90 days so you get out of jail first.
Okay.
Okay?
Okay.
You mind if I dated that for you, sir?
Mm-hmm.
Is that okay with you?
Yes, sir.
Okay.
Dismiss count one. I'm going to dismiss count
Okay.
one. Counts 2 and 3.
appreciate that.
That's all right, I got another one. All right, Judge, one.
All right, Mr. Nitsky, can you, there's no F at the end of his name, it's just a typo. All right, thank you, sir. All right, Mr. Nitsky, can you raise your right hand? Do you swear or affirm that the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth?
Anthony Niski, 3/13/1995.
All right, and you're here in 24 CF 2939. You're currently charged with grand theft and possession of a controlled substance, both third-degree felonies and also drug paraphernalia, first-degree misdemeanor. I've been handed a plea and sentencing agreement that calls for you to plea to counts 2 and 3, so that's the controlled substance and the drug paraphernalia, 60 days county jail. Is that what you want to do?
Yes, sir. Credit for time served?
Of course.
Yes, sir.
All right, have you gone over this plea and sentencing agreement with Mr. Williams? Did you understand it?
Sir.
All right, and did you sign it?
Yes, sir.
Are you satisfied with Mr. Williams' advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or
No, sir.
concerns? Anyone force, pressure, or threaten you to do this?
No, sir.
Anyone promise you anything in return for doing this?
No, sir.
Do you understand there won't be a trial of any kind if you enter a plea?
Yes, sir.
You understand you're giving up your trial rights that are here on page 1, continuing over to page 2?
Sir.
And you understand you're waiving all potential defenses that you may have?
Yes, sir.
All right, what is your plea to counts 2 and 3?
No contest.
I'll accept your no contest plea to counts 2 and 3. State have an announcement on count 1.
Dismiss that count.
Okay, dismiss the grand theft. I'm going to adjudicate you guilty on both 2 and 3. 60 days county jail, credit for time served, $615 in court costs, $150 PD fee. You've got 90 days to either pay or enter a payment plan. Otherwise, those monies will go to collections. You understand that, Mr. Nitsky?
Yes, sir.
All right, I need you to be fingerprinted. Concurrent. You've got 30 days to appeal the judgment and sentence of this guideline sentence. Step over, be fingerprinted, sir.
That's all I had on my list. Say it's foolproof, but, actually I had